Welcome everyone to the Seoul Copyright Forum 2025. I am Ivanova and I will be your host for today's event. It is an honor to join such a significant event. I would like to thank all of you for joining us despite your busy schedules, and also to all participants joining us online. Thank you for joining us today. The theme of the Seoul Copyright Forum 2025 is Generative AI and Copyright, a Global Summit. Following years 2019, 2023, and 2024, this is the fourth year dedicated to the theme of Generative AI. This is a testament to the significance of Generative AI worldwide, and we would be remiss not to explore this topic in the copyright sector. The previous three forums were dedicated to exploring generative AI's creative tools and relevant copyright issues, legal tasks, along with government initiatives across different countries. Striking the right balance amongst various stakeholders in the process is the new challenge of the era as the copyright sector meets a significant transition. To collect insights and experiences, we will hear from experts coming from the government, academia, and the industry. So please stay with us until the very end and contribute your wisdom to resolving this challenge of our time. Today's program will start with welcome remarks and opening remarks. And in the first session, we will hear from the government of Korea, Japan, Singapore, and EU about the government initiatives and policies. And the second session, we will hear from speakers representing the creators and the industry on how generative AI and copyright issues can be tackled. And then today's program will end with a panel discussion. We will now invite Sejong, Director General of Copyright Bureau of the Ministry of Culture, Sports and Tourism for her welcome remarks. Please welcome her with a big hand.
Good afternoon, ladies and gentlemen. My name is Hyangmi Chung. I'm the Director General of the Copyright Bureau of the MCST. I would like to say that I'm very happy to be hosting this Seoul Copyright Forum 2025. And I'd particularly like to welcome everyone who are here with us today in Seoul, Korea, but also those of you who are participating remotely from various parts of the world. I'd like to welcome all of you. Also, I would like to particularly thank our distinguished guests who are here with us as speakers and moderator, namely Professor Tatsuhiro Ueno of the University of Waseda School of Law, Mr. Gavin Fu, the head of the copyright unit of the legal department of the IP Office of Singapore, Mr. Sakchon Ham, the president of the Copyright Choreography Copyright Society of Korea, and Mr. James Cheatley of the MPA Asia Pacific, and Ms. Rachel Lee of Amazon Web Services, Head of Economic and AI Policy, and also Professor Seung-jae Choi, Professor of Law of Sejong University. I would also like to thank Ms. Jordanka Ivanova, the Head of Legal Oversight of AI Act Implementation from the AI Office of EU, for sending us her video of a presentation. The Article 1 of the Copyright Act of Korea states that the purpose of the Act is to protect the rights of authors to promote fair use of works in order to contribute to the improvement and development of culture and related industries. And this provision clearly states the core purpose of the copyright regime, which is to strike a balance between the two values of protecting copyright and also facilitating the use of works so that culture and related industries can develop sustainably. Today, we are facing astonishing development of AI technology and related industries, which is leading to unprecedented form of use of works, but also creating an environment for new ways for content to be created. So there are new policy challenges that we are facing together around the world. For example, there is the issue of striking balances between various different issues. For example, between copyright protection and the promotion of use of works, and also between copyright protection and development of AI industries. The government of the Republic of Korea, in order to find some solutions to these issues, created in 2023 the AI Copyright Law Working Group and also published a guide to generative AI and copyright. And this year, this working group is now in its third session, and soon other guidelines will be published regarding to the output of AI. So, for example, a guide to copyright registration of the work created using GenAI tools, and also a guide to prevent copyright disputes concerning generative AI outputs. The reason why Korea was able to go about these initiatives was precisely because of the mutual assistance and cooperation from our overseas partners. So I'd like to take this opportunity to thank all the global experts who are here with us, who will be rendering their valuable insight. And I believe that today's discussion will contribute to our finding of new opportunities for humanity's creativity that had driven the history of cultural prosperity to leap forward rather than be constrained by a sense of crisis. So going forward, I look forward to your continued interest in the Seoul Copyright Forum. And last but not least, I would like to thank the chairperson of the KCC, Mr. Sejong, Kang, and his staff at the KCC for organizing today's forum. Thank you very much.
네, 감사합니다.
Thank you very much. She has touched upon the significance of today's forum. Thank you very much, Director General Chang. Now I'd like to invite Mr. Sejong Kang, who's the chairperson of the Korea Copyright Commission, for his opening remarks. Let's welcome him to the stage with a big round of applause.
존경하는
Distinguished guests and all participants joining us through online streaming, good afternoon. I am Kang Seok-won, Chairman of the Korea Copyright Commission. I'm delighted that we are once again hosting the Seoul Copyright Forum, Korea's leading international conference on copyright this year, with such a huge turnout. As this year marks the 18th Seoul Copyright Forum, I'd like to thank Director General Sejong of MCST and all members of the Copyright Bureau who made this event a success. Also, my deepest thanks goes out to all speakers who traveled distances. Professor Tatsuhiro Ueno of University of Waseda School of Law, Mr. Gavin Fu, head of the Copyright Unit at the Intellectual Property Office of Singapore, Vice President James Cheatley of the Motion Picture Association, Ms. Rachel Lee, head of AI Policy at AWS APAC Hub, and also to Ms. Jordanka Ivanova of the EU Commission AI Office joining us through her video. I also deeply thank Director Choi Young-jin of the MCSD Copyright Bureau, who will walk us through Korea's policies, and Attorney Ham Seok-chan, President of the Choreography Copyright Society of Korea, who will speak on behalf of the creators, and Professor Choi Sung-jae, who teaches law at Sejong University and will be moderating the panel discussion. This year's 2025 Seoul Copyright Forum will delve deeper into the topic of generative AI and copyright, already explored in years 2023 and 2024. After ChatGPT was released to the global public in 2022, generative AI was adopted in various creative activities, calling for an effort to find the balance between the advancement of the AI industry and protection of copyright. In last year's forum, we looked into right holders' permission and compensation regarding works used for AI training, labeling obligation of AI-generated content, among various copyright issues and each country's policy efforts. In today's forum, we will hear from experts coming from Korea, the US, Japan, Singapore, and the EU to share 2 years' worth of policy initiatives and discourses. And we will together navigate the future of Gen AI and copyright policies from a broader perspective. Also, Choreography Copyright Society of Korea and MPA will speak for creators and the creative industry on how they view and experience Gen AI, followed by Amazon Web Services talk on how an AI company strives to harmonize tech innovation with protection of creator rights. Sessions will be followed by a panel discussion where we will seek to provide insights on how creators and AI tech can together promote innovation and mutual growth of the culture industry in this era of generative AI. I hope this forum will serve as a significant milestone on our journey to find a balance between the AI industry advancement and copyright protection. I once again thank all speakers and participants from home and abroad, and especially for those who've traveled from afar. I wish your short stay in Korea will be filled with great memories. Thank you.
네, 감사합니다.
Thank you very much, Mr. Kang. He has touched upon some of the issues that will be dealt today. So we have heard the opening and the welcoming remarks, and I very much look forward to the discussion today. Thank you very much, Chairman Kang. So that will be it for the opening ceremony of the Seoul Copyright Forum 2025. Before we go into the first session, I would like to invite the distinguished guests for a commemorative photograph. Please come up to the stage when your name is called. Hyangmi Chung of the MCST, Sejong Kang of the KCC, Gavin Fu of the Singapore IP Office, James Cheatley of the NPA, Tatsuhiro Ueno, Professor of Waseda University. From AWS, Rachel Lee. Please come up to the stage. Ms. Youngjin Choi of the MCST. Please come up to the stage also. And Mr. Seokchun Ham from the Choreography Copyright Society and Professor Seung-jae Choi of Sejong University. I would like to ask all of you to come up to the stage.
네, 이제 기념 촬영을 진행.
Yes, please smile for the camera.
One for joining us on stage. We're going to now begin a photo opportunity. We will first start with just a regular at-ease posture, but please don't forget to show your best smile. 먼저 정자세로 찍겠습니다. 환한 미소 부탁드리겠습니다. 네, 다음으로 두 번째 포즈 가겠습니다. 저작권위원회의 밝은 미래를 기원하면서 한국인이 좋아하는 화이팅 포즈 한번 가볼까요? Let's make the right fist. We Koreans love to say fighting to hope for the better future. 1, 2, 3. 하나, 둘, 셋. 화이팅! Thank you. 네, 감사합니다. 이상으로 VIP 분들 모시고.
Thank you very much. You may now go back to your seats.
Thank you very much once again for your cooperation. 네, 그럼
Great, and now we will commence the Seoul Copyright Forum 2025. The first session will explore the theme of policy developments for copyright and Gen AI. We will hear about the policy efforts of Korea, Japan, Singapore, and the EU from experts from the government. The first presentation will explore the copyright regime improvement and the copyright policies in the era of AI from Director Choi Young-jin of the Copyright Bureau of MCST as he leads the mid to long-term direction of the copyright policies of Korea and establishing the legal foundation. Please welcome him with a big hand.
문화체육관광부 저작권 정책.
Hello, I am Director Young-jin Choi, and being able to speak in front of such an insightful audience and introduce the policy efforts of Korea's policies regarding copyright is such a great honor.
네, 오늘
So today my presentation will cover 4 topics. First, the Gen AI and Copyright Working Group of MCST, and second, the copyright questions concerning Gen AI, and third, the public opinion survey that we conducted as a ministry, and fourth, about the government initiatives surrounding the topic. So this is the progress of the Gen AI Copyright Working Group of MCST. So with various experts from the tech industry and the government and the academia, we have formed a working group to explore this topic. We have discovered the issues and received feedback from stakeholders, and then we began to work on a guide on generative AI and copyright. And in 2023 December, the guidebook has been published. It mainly explores the trends regarding Gen AI and copyright and the legal regime in other countries. AI developers and right holders and users were introduced to some issues to keep in mind. And that was the purpose of this guidebook. And in 2024, we ran the second season of the working group. We had 2 breakout groups, AI training and AI outputs, and we held 15 meetings. First, regarding the breakout group on AI trading, how to clear rights for AI training data and disclosure of the data used, and improvement of the copyright regime were explored. Regarding the AI training data, the developer and the right holders must come to a compromise based on the support, and also to balance industry development and the right holder protection. We need further protection and support. And also for transparency and right protection, first, the neighboring right holders and the right holders must be aware that their works are used as training data. So the exact scope of works that could be used for training data was an issue to be explored, and labeling the AI outputs and infringing works and providing a guide for registration of AI outputs were also explored in Season 3. And further discussion on the labeling requirement and deployment of AI and its outputs, and coming up with the criteria to distinguish what is infringing work or not were necessary. That is why we had to conduct season 3 of the working group. So breakout group 1 explored protecting copyright while training AI models, 2 facilitating data set transactions, and 3 utilizing AI outputs. So 6 meetings were held. When it comes to protecting copyright while training AI models, they looked at exemption and other regimes that allows for using works for AI training data and exploring measures to improve the copyright regime. So we take into consideration international agreements or treaties and our Constitution and our Copyright Act. And when it comes to bilateral FTA, we seek adequate protection of the right holders without expanding the protection to an excessive extent. And for when it comes to TDM exemption, we need to review such a policy according to the feedback. And there was opinion that it should also cover exemption to web crawling. And also when it comes to opt-out, the intent of opt-out should be respected, and the AI developers agree, but the practical aspects of how to implement that aspect needs a very cautious approach, according to the feedback that we have received.
두 번.
And in the second breakout group on facilitating data set transactions based on the need for AI training data, we are running negotiating tables, and scalability and effectiveness and the right level of compensation will be explored. And starting from literature works, we will expand the policies to cover other works. And the third breakout group on utilizing AI outputs focused on dispute prevention and publishing a guideline, and also plans to explore more in-depth topics about the use of AI outputs. And copyright questions concerning Gen AI. When it comes to AI training data, TDM exemptions and transparency concerning AI training were explored. So when it comes to a TDM exemption, the direction of regulation, the scope of permission, and the technical expression of intent are some topics to be reviewed, and the FTAs and treaties joined by Korea and the fair use provision under Korea's Copyright Act are some issues to be explored. And when it comes to transparency of the training data, the exact scope and method of disclosure and its impact on trade secrets will be deliberated. And when it comes to facilitating transactions, those who wish to purchase data and the right holder groups will negotiate with support of the official regime, and various alternatives will be explored. So as a neutral intermediary, the needs and interests of both sides will be taken into account.
And regarding the AI output, there are a variety of different issues that we are dealing with. For example, the eligibility for copyright registration of a work that used AI tools, and also what the criteria are going to be to determine the copyright infringement of an AI output, and also the issue of labeling of AI output. So for example, which are kind of output and methods, and what are the resources that are needed to implement such labeling are being discussed. So since 2024, from November and December, there was a stakeholder feedback that was received from the rights holders, the AI industry, and also the general public. So, for example, in the case of the general public, many people showed strong support for compensating rights holders for those whose works have been used by training of Gen AI, and also there was a lot of broad consensus. For example, 87.5% of the respondents said that they do welcome labeling requirements for AI-generated works. Regarding the rights holders group, they showed strong support for prior permission from copyright holders, so they were opposing the TDM exception, and they also wanted government to mandate the requirement of the disclosure of the training data. The AI industry, on the other hand, were in favor of introducing the TDM exemptions, but with an opt-out option, and they also raised a lot of concern regarding that the disclosing of the training data could breach trade secrets, and they also emphasize the need to consider whether to make labeling of AI-generated works sufficiently visible or not. And so the Korean government is also implementing some preemptive initiatives, not just going through the legislative reform. And it was actually mentioned by the Director General of the MCST in her opening remarks. So, for example, a guide to copyright registration of a work created using Gen AI tools, and a guide for public to prevent copyright disputes concerning generative AI outputs. So these two guides are going to be published quite soon. So let me talk a little bit about the copyright registration guide. There are going to be 3 different things that are going to be in the guide. One is regarding the Gen AI and the copyrightability or the registrability of those kind of works, and also general overview of the registration, and thirdly of the practical aspects. The first of all, whether or not AI generated works can be registered or not. Basically, it will depend on whether there has been a human contribution, and so those AI generated works but had been edited or contributed by human creativity will be able to be registered. Secondly, there will be a guide regarding the scope of the works undergoing registration. And thirdly, regarding the practical aspects, there will be some guide regarding any false registration or some examples of registration of AI-assisted works. The second guide, which is regarding the prevention of conflict, will also contain largely 3 different issues. The first of all, it will be about the concept of the output and also about some kind of a possible conflict. The secondly is about the criteria and what kind of aspects will be considered when determining when there is an infringement. And thirdly is about general guidelines for the industry and practitioners. So we will be differentiating the AI-generated output versus those that had been assisted by AI. And so there would also be a guide regarding the concept of access to the original work, and also substantive similarity would also be dealt with in this second guide. Last but not least, for the general guide for the general public and also industries, there will be some criminal and administrative remedies that would be mentioned. And from the user side, there will be some guide on some cautionary warnings regarding the use of different prompts, the need to check the terms and conditions. And for businesses, the need to have technical protection measures, the need to have contractual relationship with the user, and some other issues. So our Director General talked about the purpose of the Copyright Act. So basically, it's to promote the development of cultural industries and related industries. Today, we're having a discussion of a variety of different issues, but I believe that the commonality between all of the different issues would be to talk about the benefits of the AI and technologies, and also about the compensation that is should be duly paid for the rights holders. And so these, I think, issues, you would all agree with me, should be forming the consensus. And also the Korean government is trying to strike a balance between the different values and also to come up with various solutions, the different policies and initiatives. And hopefully in the next such copyright forum, we'll be able to come up with a more updated version of these initiatives. Thank you very much.
네, 최적화된 균형을 위해서
So for the optimal balance, Korea is making a lot of policy efforts. So it was a very insightful and fruitful presentation. And thank you, Director Director Youngjin Choi once again. We will now move on to the second presentation, which will be delivered by Professor Tatsuhiro UENO, Director of the Research Center for the Legal System of Intellectual Property and the Institute of Comparative Law at the Waseda University. So let's welcome Professor to the stage with a big hand.
Have a pause.
Good afternoon, ladies and gentlemen. My name is Tatsuhiro Ueno. It's really good to be back in Seoul once again.
감사합니다. Now, let me switch to English. It's a great pleasure to come back to Seoul again. Fortunately, as you can see, I have received many invitations to visit Korea since 2014. I'm very happy to come back Seoul regularly, to see my old friends, and to make new friends each time. I'd like to appreciate the MCST and the Korea Copyright Commission for providing me with such wonderful opportunities. Today, I'm going to talk about the recent discussions about text and data mining, TDM, copyright exception in Japan. As many of you may know, the Japanese Copyright Act has an explicit provision for text and data mining. This provision was originally introduced in 2009, 16 years ago. I would say that Japan is the first country in the world to introduce a TDM copyright exception. This provision, originally Article 47.7, was amended in 2018 to extend the scope of copyright exception. Let me introduce this provision. This is the Japanese CDM exception. It is now included in Article 34, also known as the copyright exception for non-enjoyment use. Article 34 allows an exploitation of a work that is not aimed at enjoying a work or causing another person to enjoy a work. But you may be wondering what non-enjoyment use is. But Article 34 provides 3 examples of the non-enjoyment use, and as you can see, one of which is information analysis in item 2, which is almost synonymous with text and data mining. In other words, TDM is regarded as one typical example of the non-enjoyment use. So let me take some examples. If you analyze a massive number of medical articles, you might be able to discover a new medicine. Similarly, if you analyze a large number of tweets on Twitter X, you might be able to predict the future trend, which is very valuable for business marketing. In both cases, it is true that you are copying copyrighted works without authorization. However, this copying is only for analyzing the data in the works, not for enjoying them. In other words, nobody is appreciating the original expression. Nobody enjoys the work. This is why TDM is considered as a non-enjoyment use. But you may still wondering about the justification for text and data mining copyright exception. Why is text and data mining or non-enjoyment use permitted? So let me briefly explain the basic idea behind this provision. The idea is that copyright is a right protecting only an interest in the inherent exploitations which are aimed at enjoying a work or causing someone to enjoy a work. For example, in the case of a book publication or movie screening, the exploitation of the work is aimed at causing the public to enjoy the work. Therefore, copyright should cover such exploitation. On the other hand, in the case of text and data mining, nobody enjoys the original expression of the work. Therefore, such use doesn't need to be covered by copyright. This is the theoretical background to this provision. I call this the internal limit theory. The Japanese TDM exception is based on the internal limit theory rather than external limit. But I won't go into detail today. Instead, let me talk about the substantial requirements of the Japanese TDM exception. This is much more important in practice. First, the Japanese TDM exception applies not only to non-commercial scientific research, but also to commercial TDM activities. Therefore, a business company such as OpenAI or Stability AI is allowed to use the copyrighted works for the purpose of commercial TDM activities if it is carried out in Japan. And the EU directive has the opt-out mechanism, but the Japanese TDM exception has no opt-out mechanism. So the right holders cannot refuse TDM activities under the Japanese law. As a result, when you conduct TDM activities in Japan, you don't need to check whether the copyrighted holders have opted out or not. Second, in terms of allowed acts, under the EU directive, reproductions are allowed. On the other hand, under the current Japanese law, it is permissible to exploit a work in any way and to the extent considered necessary. This means that an exploitation other than reproduction, such as the distribution and the communication to the public of a training data set containing copyrighted works, can be permitted, insofar as it is carried out for another person's TDM activities and to the extent considered necessary. Third, no lawful access requirement. Under the EU directive, it is allowed to use lawfully accessible works. On the other hand, the Japanese TDM exception has no such requirement. Therefore, if you obtain the works by circumventing the paywalls or access control, you are still allowed to copy them for the purpose of text and data mining under the Japanese law. So it is not copyright infringement, but you may be in breach of contract. Fourth, no lawful copy requirement. Under the Singaporean TDM exception, there is a lawful copy requirement in principle. On the other hand, the Japanese TDM exception has no such requirement. Therefore, even if you download a number of movies from an obviously illegal website, you are still allowed to copy them for the purpose of text and data mining. However, it should be noted that there is no provision in Japan on the unenforceability of a contractual override. Contractual provision contrary to copyright exception. So that means a contract prohibiting TDM activities would be enforceable under the Japanese law. Additionally, there is no provision on the technological override in the Japanese law. So by using technological measures, right holders might be able to prevent users from conducting TDM. Moreover, there is no provision, so the Japanese TDM exception has the proviso. So the Japanese TDM exception is applicable unless it would unreasonably prejudice the interests of the copyright holders. So this slide illustrates the differences between jurisdictions. It is a little complicated. But I would say that the Japanese TDM exception is the broadest one in the world. So that's why I have been saying that Japan is the machine learning paradise. And I would like to emphasize that it is here in Seoul that I first used this phrase, namely at the Seoul Copyright Forum in 2016. About 10 years ago. Since then, I have been suggesting the Japanese companies to take advantage of the Japanese broad TDM exception. But what impact has the Japanese TDM exception had on Japanese industry or economy? In fact, many people ask me about the outcome of the Japanese broad TDM exception. I think many of you in this room are wondering about the outcome of the Japanese TDM exception. But unfortunately, there's no evidence that the Japanese TDM exception has had a positive impact on the AI economy in Japan. In the meantime, the rapid development of generative AI technology sparked heated debate about the Japanese TDM exception. Currently, copyright holders, such as newspaper companies and the individual illustrators in Japan, are very much concerned about the TDM exception. So now, I'd like to talk about the recent discussions on the TDM exception in Japan. As mentioned before, some of copyright holders are concerned about the TDM exceptions in Japan. However, the Japanese government decided not to change the existing TDM exception to facilitate AI business. And instead, the Agency for Cultural Affairs released a guideline about AI and copyright on March 15, 2024, last year, to clarify the general understanding. This guideline was prepared by the subcommittee of the Council for Cultural Affairs. As you can see, I was also a member of the subcommittee. I was involved in the drafting process of the guideline, but I must say that there were very heated debate. For example, there was a public consultation on the draft of the report before finalizing it. Surprisingly, around 25,000 responses were sent to the government. To be honest, we were extremely exhausted. This is the final version of the guideline. It is written in Japanese. No English translation. Only the overview has been translated into English. However, if we want a precise understanding of the guideline, I recommend you to read the guideline itself, because the English overview contains some misleading description in my eyes. So anyway, I'm sure that this guideline is very, very informative, but I'm afraid that it is terribly complicated and very difficult to understand, even for Japanese people, even for Japanese experts. Today, I'd like to focus on the main points relating to the TDM exception. So first, the coexistence of the enjoyment purpose. Generally speaking, if an AI output is similar to the original work in the level of the original expression, then such an AI output constitutes copyright infringement. And if you didn't intend to generate such copyright infringing content during the training process, the AI training does not constitute copyright infringement under the TDM exception. However, if you did intend to generate copyright infringing content during the training process, Article 34 is not applicable to such a training, because there was not only a non-enjoyment purpose, but also an enjoyment purpose. Second, database work created for TDM activities. This is the case 1 of the proviso of Article 34. As mentioned before, Article 34 has the proviso. Therefore, Article 34 is not applicable if the exploitation would unreasonably prejudice the interests of the copyright holders. In this regard, it is widely accepted that the Japanese TDM exception is not applicable to a data set as database work prepared for the use of TDM, because the old version of the Japanese TDM exception before 2018, Article 47.7, database works prepared for TDM activities were clearly excluded from copyright exception. Therefore, even after the amendment in 2018, Article 34 doesn't apply to database created for TDM activities. For example, if a newspaper company creates a database containing a large number of news articles for text and data mining activities, Article 34 does not apply to the use of the database for TDM activities. Against this background, according to the guideline, if you collect a large number of freely accessible news articles in the internet by scraping in order to conduct TDM activities, and if the newspaper company sells the database for AI developers containing the news articles, collecting news articles from the internet without payment might constitute copyright infringement of the said database work, because it may unreasonably prejudice the interests of the copyright owner of the said database work. To be honest, this part of the guideline was one of the most controversial ones. Therefore, there were several skeptical or opposing opinions in the subcommittee. Such opposing opinions can be found in the footnote of the guideline. So I recommend you to read not only the main part of the guideline, but also the footnotes. It is completely difficult to understand, but I recommend you. So next, the case 2 of the proviso is a pick of training. Let me talk about the Ghiblification. As you know, ChatGPT can be used to transform any image into a Ghibli-style image. This is my picture. You may feel this is too young. Anyway, the style itself is not subject to copyright. This is another example. As you know, the idea-expression dichotomy is widely accepted around the world. Therefore, you can use the Ghibli style freely. But what about the pick of training? If you train an AI by using a particular creator's works to create an AI that can generate a massive amount of outputs similar to the original work in the style, such AI output may harm the creator's interests. Therefore, when we discussed in the subcommittee, 3 or 4 members argued that such a pick of training could constitute copyright infringement based on the proviso of Article 34, because such style-similar outputs unreasonably prejudice the creator's interests. However, this was the minority view. According to the majority view of the subcommittee or the guideline, including my own, even if a large amount of output with a similar style might harm the copyright creator's interests, both the training and the generation would not constitute copyright infringement because they would not unreasonably prejudice the interests protected by copyright. However, this issue was quite controversial in the guideline. So those were the main points of the guideline. So now let me point out some things about TDM exception. First, it is important to distinguish between input and output. The TDM exception only applies to input, not output. If an AI output is similar to the original work, not only in the style, but also at the level of original expression, it obviously constitutes copyright infringement. In fact, these are the images generated by the Stable Diffusion in response to my prompt, a girl holding the Pikachu. If you use these images publicly, it might constitute copyright infringement. That's why some generative AI models have recently started avoiding the generation of copyright infringing content. For example, I tried to input the prompt and asked the ChatGPT to generate popular characters such as the line Friends, which is my favorite, or Chikawa and Hello Kitty. However, the ChatGPT refused it and instead produced these contents, which are not similar to the original expression of Chikawa or Hello Kitty. However, in the case of not famous character, it is difficult for the AI user to know the AI output constitutes copyright infringement. According to the majority view, even if you were unaware of the original work, if the AI output is similar to the original trained work at the level of original expression, it constitutes copyright infringement. This was a controversial point too. Therefore, we should recognize that there is a risk of an intentional copyright infringement when using generative AI. And filtering technology will become more important in the future. So also, I'd like to emphasize the importance of the contract, at least in Japan. Based on the Japanese TDM exception, it is not necessary to obtain authorization from copyright holders to use copyrighted works for text and data mining. Nevertheless, it is still possible and meaningful for AI developers to conclude a contract with copyright holders regarding the use of large amounts of data for AI training purposes. In fact, many copyright holders, such as publishers and photo agencies in Japan, have already concluded the contracts with AI developers. This is a win-win relationship between AI developers and copyright holders. Whether this contract is a copyright-based license or not is quite irrelevant here. So, in conclusion, let me briefly summarize my talk. TDM, text and data mining, brings us significant social benefits. I think that Korean Fair Use Clause, Article 35(3), can deal with this issue. However, I still believe that introducing a specific TDM exception would be beneficial. Therefore, I recommend you introducing a TDM exception similar to the Japanese one. Of course, many copyright holders may be concerned about the TDM copyright exception at the moment. But it is more important to create a win-win relationship between AI developers and copyright owners regarding the use of large amount of data to train AI. Regardless of the existence of the TDM exception. Generally speaking, new technologies have always raised concerns. We have addressed the new legal issues arising from technological developments throughout the long history of copyright law. However, people usually become accustomed to any new technology within a few years. I suppose that generative AI will soon become part of everyday life. Therefore, we have to deal with this issue calmly, and we should continue to seek a proper balance and a reasonable compromise between the stakeholders. 감사합니다.
네, 이번에는
We heard about the Gen AI policies of Japan. So once again, thank you, Professor UENO, for your insightful presentation. We will now move on to our third presentation. Our next speaker develops and reviews Singapore's copyright policies and laws and advises the Singaporean government on AI and copyright. Please welcome Mr. Gavin Fu, Head of Copyright Unit at Intellectual Property Office of Singapore. Please welcome Mr. Fu with a big hand.
Very good afternoon, everyone. Let me start by expressing my deep appreciation to the Korea Copyright Commission for organizing this event and inviting me to speak. To the host, the Ministry of Culture, Sports and Tourism, thank you for your excellent hospitality. It's truly a privilege to be once again invited to speak at the Seoul Copyright Forum. The last time I was at this very venue was in 2023, where I spoke in quite a fair bit of detail on Singapore's text and data mining exception, what we call our computational data analysis exception, or the CDA exception for short. When the organizers reached out to me this year, I was told that this audience might be interested to hear about the evolution of Singapore's Gen AI or copyright policy initiatives, particularly the approach taken by us through the CDA exception to balance the interests of our stakeholders. So in line with that, I will spend quite some time talking about the CDA exception and share about recent developments since the exception was first introduced. But more importantly, what I want to do is to situate our discussion today beyond the confines of the CDA exception. Because in thinking about what is the balance that we have in our regime, we look more broadly at the wider value chain for generative AI. The CDA exception relates to the AI development or the input stage, but downstream, after the generative AI model is developed and deployed, there are also issues in relation to the copyrightability of the AI-generated output. So I'll spend a little bit of time explaining Singapore's position on the copyrightability of such output. Then I will wrap up our discussion today by pulling together the various threads and discussing how we have calibrated the overall balance in the generative AI value chain through the positions that we have taken both at the AI development stage as well as the AI deployment stage. So first, AI training and the CDA exception. Here you have a timeline showing the key developments relating to the CDA exception. The exception was introduced in November 2021. That's when it came into force under the Revamped Copyright Act 2021. And about a year later, that's when you had really the boom in generative AI with the public release of ChatGPT. And while the exception seems to predate the boom in generative AI, when the exception was introduced in Parliament, there was already a clear sense that the exception would be useful for AI and machine learning in Singapore, and that's why we had crafted the exception deliberately in a manner that's technologically neutral. So we fast forward about 2 years, April to June last year, That's when we had our public consultation on the exceptions to the circumvention of technological measures, including whether to allow circumvention for text and data mining or computational data analysis purposes. And as I will share more later, we eventually decided against it, and as a result of our decision, we reinforced the effectiveness of the lawful access safeguard in the CDA exception. I also want to highlight that alongside these legislative developments, there were also parallel developments in licensing, where AI developers and users were also obtaining paid or licensed access pursuant to subscriptions and negotiated deals, and I will share more about that later as well. So how has the exception been received since it was first introduced? I think, by and large, it's been very welcomed by AI developers, researchers, and related businesses for bringing greater legal certainty and AI innovation. We experienced increased business activities in Singapore in the AI space, such as the opening of ChatGPT's regional office in Singapore last year. You can also see from the slide the headlines in a few commentaries on the exception. And a common thread across these commentaries is that legal certainty is probably the biggest benefit of the exception. Because without the exception, AI training activities will need to rely on fair use. But as some of you know, there are also certain limitations to fair use. Given the highly fact-specific nature of fair use, it can often be unpredictable how the courts will weigh the various factors in determining whether fair use would apply. And in Singapore, where copyright is not heavily litigated, the likelihood of getting guidance from the courts is generally low. And furthermore, even with a ruling, this may still not give sufficient certainty to researchers and businesses. As we know from US jurisprudence, you could have conflicting court decisions, or because fair use is so fact-specific, you might end up with a ruling that is only narrowly confined to the facts and not broad enough to be applicable to most businesses engaging in text and data mining and AI development. So that is generally the feedback from the side of users, businesses, and technology companies. And at the same time, we've also been engaging with the rights owners, particularly from the creative industry. And these engagements have prompted questions about whether the balance that we've struck continues to be appropriate and whether there are steps that can be taken to better protect rights owners' interests. So in calibrating the right balance, it's always challenging to find what we call the Goldilocks zone, not too hot and not too cold. And in the context of this exception, it's really about finding an exception that is broad enough to facilitate text and data mining and machine learning users, but also an exception that can take into account copyright owners' legitimate rights and interests. Some of the key policy considerations that we weighed in striking this balance are set out on this slide. These continue to be relevant even after the exception was introduced, and they still reflect the main concerns of our stakeholders. While we have a wide range of stakeholders, the most polarized opinions have been from two groups of stakeholders: the AI developers on the one hand, and on the other hand, the copyright owners. For the copyright owners, they have advocated for contractual and licensing solutions to have the ability to opt out from AI training, and for contracts to exclude the applicability of the exception. Whereas from the perspective of the AI developers, such solutions would limit accessibility to data and could result in AI being trained on poor quality or limited data sets, which could then introduce more bias, errors, or inconsistencies in the AI output. Another key concern of copyright owners is ensuring appropriate remuneration or compensation when their works are used for AI training. And on the other hand, for the AI developers, given the large volume of data needed for machine learning, they're concerned about how it may be impractical to obtain consent in every case and the associated costs of doing so. They say that where there are no exceptions in place and the only legal means for AI developers and businesses to obtain access to data is through licensing, this risks imposing a disproportionate financial barrier on the smaller developers and businesses that want to adopt AI. So how do we reconcile these perspectives through the CDA exception? We have features to ensure that the exception would be broad enough to facilitate text and data mining and machine learning users, and these are in blue in the top half of the slide. And on the other hand, we also have stringent safeguards to balance the legitimate interests of rights owners and to ensure that they can still receive compensation, and these are in red in the bottom half of the slide. So we've been talking a lot about CDA, but really what does it mean? Under the Act, our definition embodies the concept of non-expressive or non-consumptive use of copyright works. It's that same concept similar to what you've heard from in the Japan text and data mining exception when you talk about non-enjoyment uses. And the definition under Singapore's legislation refers to the use of copyright works as information or data, or identifying, extracting, or analyzing information or data from those works. And we've been talking a lot about AI, but actually the exception is not a generative AI or even an AI exception per se. It's deliberately drafted to be technology neutral so that it can continue to stay relevant in light of technological developments. The exception applies to all sorts of CDA activities, which can include text and data mining, sentiment analysis, and machine learning. The exception covers all copyright works and applies to both commercial and non-commercial users. And that's important for us because in our view, there isn't always a clear line between what's commercial and non-commercial in nature. A non-commercial research project can end up having commercial applications. But more importantly, because we take the view that text and data mining is fundamentally non-expressive use, whether or not commercial users are allowed becomes secondary. Users are not copying to enjoy the creative expression in the works. Rather, they are using the works as data to train the AI, and data is not protected by copyright. This remains the case regardless of whether we are referring to commercial or non-commercial users. Another feature is that the exception cannot be contractually restricted or excluded, as you've already heard. As I explained earlier, AI developers surfaced concerns about having access to sufficient high-quality data to minimize the risk of inconsistencies and bias. This perspective was acknowledged when the exception was debated in Parliament. The parliamentary debates in Singapore emphasized the importance of not allowing private contractual provisions to override this exception because the benefit of data analysis improves with the completeness of the underlying data. Having specific databases locked out of the analysis because of contractual restrictions would make the results less useful or create more bias or inaccuracies or reinforce stereotypes in the output that's generated by the AI. Next, we come to the safeguards that we put in place to balance rights owners' legitimate interests. First, the exception is limited to acts of copying and in very narrow circumstances, communication. It is not a broad exception that applies to other exclusive rights that are not relevant to computational data analysis. Generally, the works cannot be communicated or supplied to others. And the only circumstances where this is allowed is verifying the results of the CDA or collaborative research or study relating to the CDA. A user that communicates or supplies the works to a third party in any other circumstances would infringe copyright, as the exception would not apply. And this is an important safeguard because it ensures that we continue to protect rights owners' markets and require their licensees to obtain access to works lawfully. And that brings me to the lawful access condition. It's a key safeguard for us as it is a crucial condition that helps to address rights holders' concerns about remuneration, which I talked about in the previous slide. This safeguard helps to preserve and protect rights owners' commercial interests and freedom to conduct business based on licensing and subscription models for access. We recently reinforced the lawful access condition, as I just mentioned, and I'll talk more about it shortly. And finally, the use of infringing copies is restricted. Generally, users cannot carry out CDA on copies that they know are infringing. And this addresses rights owners' concerns in the public consultations that the exception otherwise would have the potential to legitimize the use of infringing content. Singapore's CDA exception is one of few exceptions in the world that has this express safeguard against the use of infringing copies. So, in a nutshell, that is a broad overview of the exception, its key features and safeguards. And you can see how with a specific exception for CDA, we've been able to put in place targeted safeguards that correspond to the intended use of copyright works and address rights owners' key concerns within the specific technological context of computational data analysis. Compare this to a general exception like fair use, where it's simply not possible to prescribe technical guardrails ahead of time to control users' conduct, such as requiring users to first obtain lawful access to the works. I now turn to the 2024 review of exceptions to the circumvention of technological access control measures. We did a public consultation from April to June last year, consulting on possible exceptions to the circumvention of technological access control measures. And this was part of a periodic review that takes place at least once every 4 years in light of technological and market developments. What are access control measures? As some of you may know, they are technologies, devices, or components that rights holders often use to effectively control access to copyright works. Examples include password controls, software locks, and paywalls. In Singapore, circumventing an access control measure may lead to civil and/or criminal liability, and such liability is separate from and in addition to copyright infringement. At the same time, our law allows for exceptions. Access control measures may be circumvented in certain situations where they adversely impair legitimate non-infringing acts. Some of these exceptions are temporary in nature. They last no more than 4 years, in line with our review cycle. So what we were considering in this 2024 review was what temporary exceptions we should renew or introduce to allow circumvention of access control measures. One exception that we considered was whether to allow circumvention for TDM or CDA purposes. Unsurprisingly, again, the feedback that they received was quite polarized. For the technology companies, they urged us to introduce the exception, as they said this would advance AI technologies. Whereas for rights owners, they took the view that Singapore's AI training regime is already sufficiently permissive and should not be widened further. They said that access control measures are necessary to support the lawful access safeguard in the CDA exception. After assessing the feedback, we decided against introducing an exception to circumvention. There were 3 main reasons for this, which I will now go on to discuss. First and foremost, we agreed with rights owners that access control measures are important for giving them the ability to control access to their works and to charge for such access. To better understand this point, we need to examine the lawful access condition, which I've extracted on the slide. Our legislation gives an example of what constitutes lawful access in the illustration. So a person does not have lawful access if that person accesses the works that are used for AI training by circumventing paywalls. So therein lies the interaction between the prohibition against circumventing access control measures, like paywalls, and the ability to rely on the CDA exception. Because access to copyright works through circumventing an access control measure would be unlawful access, the lawful access condition would not be satisfied, and a user would not be able to rely on the CDA exception to avoid liability for copyright infringement. In addition, the user will also be liable for circumventing the access control measure. Hence, by not creating an exception to circumvention for the purpose of CDA or text and data mining, we had also reinforced the lawful access safeguard, which enables rights owners to then rely on access control measures to control when they want to give access to their works for AI training, and when they do want to give such access, to receive remuneration through charging for such access. The second reason is that access control measures are useful tools for rights owners in structuring existing and emerging business models and licensing arrangements. From our public consultation feedback and through our stakeholder engagements, we received evidence from both rights owners and users of successful licensing for AI model training while the CDA exception has been enforced. For example, a leading publisher headquartered in Singapore shared that they have successfully cultivated business partnerships with technology companies by licensing copyright works behind secured access control measures for purposes such as AI model training. And in fact, they shared with us that this was an area of growth for them. This sort of evidence was also found in the feedback from the users. One example is Google. They shared with us that they have licensing agreements with publishers in Singapore which would allow training on specialist scientific and educational materials. Hence, our experience has shown that the exception has not necessarily deterred industry players from entering into licensing arrangements and collaborations in relation to AI training. And in fact, such licensing arrangements can even be said to complement the exception, as these licensing arrangements bring value beyond what an exception alone allows. For instance, they can provide structured or curated training data, easier access to data through application programming interfaces or APIs, or improve speed and accuracy in citation referencing. In some cases, the data is also privately held and not available through web crawling, so licensing gives the AI developer access to such data for a price. So in many cases, access control measures are an integral part of the business model or licensing deal, as rights owners limit access to the content behind a paywall or secured database. By not allowing access control measures to be circumvented for text and data mining purposes, we have supported and encouraged the continued development of these business models and licensing arrangements. Coming to the third and final reason, access control measures strengthen the effectiveness of reasonable measures by rights owners to maintain the security and stability of their computer systems and networks. When we first announced the exception, we gave rights owners the assurance that the exception would not prevent them from taking such measures, as rights owners were concerned that their computer systems and networks would be affected by indiscriminate web scraping in the process of text and data mining. So in the 2024 review, in line with that commitment and how we want to strike the appropriate balance, we allowed rights owners to continue using access control measures to limit the impact of web scraping on their servers and avoid degradation of service levels. And with this, I come to the end of the first part of my presentation on the AI training aspects of Singapore's regime. Let me now go on briefly to talk about the AI deployment or output aspects of our regime. And here I will focus on the copyrightability of AI-generated output, specifically authorial works, meaning literary, dramatic, artistic, or musical works. And I'm referring to the scenario where the output is created entirely by AI with minimal or no human intervention, such as the usual scenario where a user inputs a simple prompt into the LLM. So the starting point is that Singapore has no legislative provision granting protection in AI or computer-generated works. This is unlike some countries like the UK. On the contrary, we have leading cases suggesting that there's no copyright in AI-generated authorial works, and these are cases by our highest court, the Court of Appeal. So for example, we have a 2011 decision by the Court of Appeal, where the court held that legal rights flowed only from human authorship, and only natural persons can be authors. The court made clear that the objective of copyright law has been to encourage the creativity of authors who are natural persons. And it would be contrary to public policy to allow corporate entities to be authors, as this could result in perpetual copyright protection, given that duration of copyright is pegged to the life of the author. We also have a 2017 decision. This was a decision of in relation to copyright in the form of telephone directories. And in that case, the court found also that the selection of contents in the listings in the directories lacked creativity and there was no copyright subsistence. The court emphasized that authorial creation must be causally connected with the engagement of the human intellect, and by that is meant the application of intellectual effort, creativity, or the exercise of mental labor, skill, or judgment. And you can see the relevance to AI-generated content as the same argument could be made, and authorial work that is generated by AI pursuant to a simple prompt lacks engagement of the human intellect. The prompter has essentially only contributed an idea, and it is the AI that determines the expression. And in such a case, the output will not be protected by copyright. I've also set out on the slide further legislative provisions in our Act that support the position that there's no copyright in AI-generated authorial works in Singapore. You can take a look at them. So in the last part of my presentation, I want to pull together the various threads of what we discussed by looking more broadly at the entire generative AI value chain. So in talking about this value chain, this is often split into two main parts of the process, as many of you know, the AI development or the input stage, and the AI deployment or the output stage. At the input stage, an AI model is often trained on copyright works, hence then there's an issue of potential copyright infringement. And that's where the CDA exception comes in. It's an exception to infringement, and what I've sought to explain earlier is how we've sought to create balance within the exception itself by taking into account the interests of the AI developers as well as the rights owners, having things like the lawful access safeguard and so on. Then I explained how, in light of rights owners' concerns about remuneration and their ability to control access to their works when used for AI training, we reinforced the lawful access condition in our 2024 review and supported rights owners' ability to rely on technological measures to protect their interests. So these were steps that were taken as part of a concerted effort to respond to rights owners' concerns and to ensure that the balance at the AI training or the AI development stage is maintained and not tilted too far in favor of the AI developers. But to fully appreciate how we have created a regime that fosters AI innovation while also taking into account rights owners' legitimate rights and interests, we need to look beyond the AI training part of the process and to also consider the position at the AI deployment or the output stage. As you know, there may be issues of infringement at the output stage, where output bears substantial similarities to existing copyright works. And it's important to emphasize that under Singapore's law, rights owners may take action against the generation or use of infringing content based on existing infringement remedies and legal principles. Then there's also the issue of copyrightability, which I've just talked about. There must be a human author for authorial works to be protected. And this is an important part of the equation because we know that creators and rights owners are concerned about generative AI displacing jobs and human creativity. So on the one part, while the CDA exception allows works to be used for training generative AI, our regime also ensures that the output the eventual application of that training is not granted copyright protection that can then be exploited in competition with the creators and rights owners of the works that are used for AI training. And since such output is not protected by copyright, it also means that others are generally free to use and build on that output, assuming there is no infringement, of course. So to summarize, when we calibrate the balance in our regime, we need to consider the issue holistically in light of the safeguards, remedies, and positions throughout the entire generative AI value chain. And sometimes the positions that we take in one part of the process can affect the considerations and the eventual position in another part of the process. So finally, I want to give you an overview of our continuing work in this area. The key message really is that AI remains top of mind in Singapore's copyright agenda. I've talked about our policy reform and legislation review work in the 2024 review. We've been having continuing engagements with a wide range of stakeholders, and we may start looking into more structured, larger-scale consultations in the near future. We're also taking a whole-of-government approach to this, meaning working with other agencies that deal with issues that may be important to the copyright stakeholders, even though they may not necessarily be copyright issues. For us, it would be issues like AI governance. And that's because we really understand that the impact of AI on the IP regime cannot be looked at in silo. We need to take a holistic approach to policy making that will support Singapore's larger national AI strategy. This also enables us to take into account these AI governance issues, such as the transparency obligations in relation to AI training datasets or the labeling of AI-generated output. We also did substantial work in contributing to international mindshare, engaging with our counterparts, of course, education and outreach among our stakeholders. I can assure you that we are paying a great deal of attention to the issues that we are discussing in today's forum. So just watch this space, and I'm sure in time to come, there'll be further developments that we can share with our stakeholders, partners, and counterparts, perhaps at the next installment of the Seoul Copyright Forum. And with that, I've come to the end of my presentation. Thank you so much for your time and attention. I look forward to engaging further with you during the Q&A.
네, 역시
Thank you very much. He had talked about some diverging opinions among the stakeholders, and so he has explained the CDA in Singapore. Thank you very much for your insightful words, Mr. Fu. So now this is going to be the last presentation for session number 1, which is going to be made by Jordanka Ivanova, Head of Sector Legal Oversight of AI Act Implementation at the European Commission of AI Office, which is in charge of supervision and coordination of the AI law, and also to support the compliance of the law, also to develop various guidelines, and also cooperate with member states and stakeholders. So she is unable to join us due to a conflicting schedule, so she has sent us a video of her presentation.
It's my pleasure to be today with you and to present to you the EU approach to artificial intelligence and copyright issues. My name is Jordanka Ivanova. I'm Head of Sector for Legal Oversight of the AI Act implementation in the EU AI Office, which has overall responsibility for the implementation of the AI Act and also full supervision of our rules for general purpose AI models. And today I'm going to present to you how EU approach and existing EU legislation are dealing with the challenges that artificial intelligence pose to copyright and how we can also make our frameworks effective. So starting first with the existing copyright legislation that we have in the European Union, we have a directive on copyright in the digital single market from 2019, which is now being already implemented in the member states. And it includes some very relevant exceptions. how data could be used in the context of text and data mining, which could be relevant also for AI training, which, as we know, requires a lot of data to make high quality and performant models. So under this directive, we have two copyright exceptions that allows the use of data, which aims to foster technological innovations while preserving incentives to human creativity and, of course, the rights also for copyright and right holders. So first, we have one of them, which is very targeted and allows the use of copyright protected content for text and data mining for research purposes. And there is always the condition that this should be there should be a lawful access. This is a narrow scope, so it's in very specific cases for scientific research purposes only, and it is unconditional, so there are no possibilities for right holders to opt out. On the other hand, we know that, of course, there are a lot of other purposes, also commercial purposes, where text and data mining could also play an important role. And for that purpose, Article 4, Paragraph 3 of the directive allows also the use of copyright-protected content subject to the lawful access of that content also to be used for text and data mining for commercial purposes. To balance, however, the rights with right holders, they still have the opportunity to expressly reserve their rights in an appropriate manner, especially in content available online. And this should be understood as also machine-readable manner. So it's a scheme of opt-out, which is quite important and gives also control of the right holders whether their content they agree to be used or not, and if they do not want to be used for text and data mining, including AI training, then they can opt out. Now, the conditions are indeed that always the parties should have lawful access. Otherwise, if they have reserved the rights through the opt-out from the right holders, that means also that if still the content is to be used by a provider, a developer of an AI model, they need to request consent. But if there is no opt-out on the copyright-protected content, that could be used then for the AI training. And now there have been a lot of also developments on the implementation of these opt-out possibilities, which should indeed enable this balance between allowing the use of data to foster AI and innovation, while at the same time also allowing the right holders to still opt out if they do not wish to do so. This is very important, and the development of such solutions to effectively express the opt-out is still now also under development, and there are relevant solutions, but there are still, of course, areas to further standardize them and make them effective. And from the EU and the Commission side, there is a process of identifying solutions and also supporting feasibility study, also of even creating a register of text and data mining opt-outs, which is now under considerations. But we have identified indeed that there are relevant challenges for right holders both both to express, but also to have the expressed opt-out respected. So here we have the reinforcement with the EU Artificial Intelligence Act, which is a major horizontal legislation, important in the European Union, already enforced as of August, which enables, with additional rules, how to address risks to safety and fundamental rights more broadly, while also supporting innovation in the single common framework, applying to all sectors and having also a very proportionate targeted approach, aiming to build trust also across the whole value chain and foster responsible innovation. We have very extensive rules and that apply to AI systems that are very graduated, based on the risks and very proportionate. While at the same time we also have more general rules for the general purpose AI models, which are the foundation of many of the downstream applications where risk can arise. But we have specific rules as well for the training and for the development and placement of the market of those models to ensure that also this transparency and accountability also across the value chain is there from the very model development. And here what's very relevant are the transparency and copyright related rules for all general purpose AI models, while also the additions for the most capable models with additional obligations for risk management and also other mitigation measures. So what's most relevant from the copyright perspective are two obligations. The first one is to put that providers of those models, placing them on the European market, because it's really important that this is not a copyright legislation, it's a market-based legislation. So for those who place the models on the European market, they should also have a policy in place to comply with Union copyright law, and in particular also to identify and comply with the text and data mining opt-out from the Digital Single Market Directive. And this already is recognized as a form of text and data mining. We as DI office are the ones responsible for the supervision of this new obligation, and this doesn't mean that providers now, or we as DI office, are going to become an enforcer of copyright legislation as such. No, of course, this is more enforced by the courts. What the providers are obliged to have in place is a policy, including some organizational measures that they put in place to comply with the copyright law, including to identify the opt-out. And this new obligation to have a policy, which is more or less conduct obligation, doesn't affect at all, of course, the existing copyright legislation that we have at place and its enforcement and implementation, which always is for right holders and also, of course, for providers that who remain liable in court if there are any violations. So what is also relevant is that this obligation also applies to all providers who place their models of the market regardless of where the model has been developed. And these obligations is now, together with other obligations, is further detailed in a code of practice that I'm going to tell you more about. But first, I want to mention also that there is another relevant obligation that could help the enforcement of copyright legislation, because what has been a major challenge is the lack of transparency for right holders to know whether their content has been used and in general what has fed into the training data of the models. So here also providers will be obliged to draw up and make publicly available a sufficiently detailed summary about the content used for the training of the models, which must be comprehensive in scope, in a narrative form, not technically detailed. And the most important is, however, that it of course should have sufficient details to facilitate parties with legitimate interest, including right holders, to enforce and exercise their rights under union law, while at the same time taking into account providers' trade secrets. So there is a careful balance here, and a lot of discussions that we have also been carrying out, and reflections, as we as the office are also obliged to provide a template for providers to provide this information in a uniform manner. Now, on the implementation of these obligations, as I said, the rules will become applicable as of August this year, but we have had this process already over the past year to develop the first code of practice with a lot of stakeholders involved, more than 1,000, in a very transparent, inclusive process based on public consultations, and to provide through this code of practice a voluntary tool for providers who wish to rely on the practices that are now agreed, bottom-up, with the industry, drafted, led by independent experts, on what could be the relevant elements to include in this policy for compliance with copyright law. And there have been multiple rounds of drafts drafted by these independent academic experts, facilitated in a process with us, with all these more than 1,000 stakeholders involved from all sectors. And we have, I'm also happy to mention, we have had also observers from our international partners who have been also able to participate in those discussions to develop these drafts. Now, everything is very much public. The third draft of the code has been published on the 11th of March, and there has been all in these iterative drafts opportunities for all stakeholders to provide input. So we are now in a final stage where the independent chairs are reflecting the stakeholder input, and we are going soon to have the final code, which then will be for the AI office to assess whether this is an adequate mean for compliance with the AI Act obligations, including on the copyright policy, but much broader. And then also we'll have a parallel assessment from the AI board, which is the body composed of our EU member states, that will also make its own assessment. We very much, given the deadline, and in this final stage, hope to have the code finalized well before August. And then also once it is available and providers and positively assessed as well, providers will be able to rely on the approved code to demonstrate compliance with the obligations. Now, zooming into what now the third code included for the copyright in particular, the objective is really for this chapter, which you all can read. It is online to support providers of the general purpose AI models to properly implement the obligation for the policy. So it's very much measures and policy they are obliged to put in place. And there are specific measures that now have been proposed in these broad discussions with all stakeholders to have the copyright policy and also relevant responsible persons within the organization for implementing, overseeing it, measures also related to the reproduction and extraction of lawfully accessible copyright protected content when crawling the web, measures to identify and comply with right reservations, with the opt-out and different solutions that providers could undertake and implement as state-of-the-art technical solutions at the moment. Then there is a measure also concerned for providers if they don't directly crawl and scrape the web, but rather obtain data from third party, to also through these parties to obtain some adequate information whether the protected content, if scraped by from the internet, has also respected relevant opt-outs. then measures also to take certain mitigation measures to address the risks of reproduction of copyright infringing output. So this is quite important because even if the text and data mining exception could possibly be relied upon for the training itself, of course, the reproduction in the outputs always remains protected and their copyright applies. So in case of outputs that are copyright infringing, of course, providers should already in their policy, despite the fact that they remain liable, but also take certain mitigating measures. And then also to designate a point of contact and enable also logic of complaints from right holders, whether providers comply with their commitments under the code. So this is very much framed within that. On the other obligation for the public summary of training data, we do, as I said, have the obligation as the office to provide the template. Our approach is very much based on what we have as obligations, stemming from the recitals to ensure reporting in a uniform, simple, effective manner, with the objective to increase the transparency and facilitate this exercise of the rights, including for right holders, while indeed balancing with what exactly granularity of information is included in the template, while taking due account of the trade secrets of the providers. And our approach, we based also on the publicly available link. You can see there some very preliminary proposals we've been discussing also with the stakeholders, receiving now input on that, how to ensure some appropriate level of granularity of the disclosure, depending also on the type of data sources, and also have some relevant information for the opt-out also, and some generic aspects more broadly, and ones related to some relevant aspects on the processing itself. So we've organized all that process as said, and already the first proposal based on stakeholder input and consultation we've received. We've had various discussions also and feedback from the Code of Practice, 1,000 participants feedback, and we've seen some common ground, but as a general note, there is still different divergences between the views on the side of providers of the granularity of information, as well as right holders who insist on full transparency. So it's now to balance and further analyze these aspects concretely in our final stages before we also adopt the template. There are just one more relevant provision for you to know on the output side of AI. We do have also obligations for transparency of the generated content. So there are separate obligations as they apply to all generative systems. On one hand, to providers to embed technical solutions in machine-readable format like watermarks to enable the detection of the AI-generated content, and also for chatbots that should be designed in way also of informing people to avoid risk of deception, and then also relevant visible labels for deepfakes and also AI-generated text publications. So these obligations, as said, are at the system level, a bit broader, and then they will apply only as of August next year. So we'll have a separate process also for to enable guidelines on their clarification as well as Code of Practice. We as the AI office are the one responsible for the supervision of all the rules for general purpose AI models. We have also a comprehensive system also for collaboration with the national market surveillance authorities, also for the systems at national level. And then we also have a number of other bodies supporting our work, cooperation with the member states in the AI board and coordination to ensure consistent and uniform implementation, as well as scientific panel of independent experts and advisory forum with stakeholders. We as the AI office have overall, in the Commission, have overall responsibility for both implementing implementing, supervising this legislation as well as far as the rules for general purpose AI models are concerned. And we'll have this key role for the future supervision also on the GPI models. And then we also have a broader mission to also support and foster innovation, and also share and collaborate with international partners as well, because it's very important also to engage in all the international discussions and foster trustworthy and address as far as possible in a common understanding the challenges we face with AI, both in terms of policy as well as regulatory measures. So here is the entry into application of the AI Act timeline. As said, we are just before the entry into application of the rules for general purpose AI models. Then we have more staged approach for the output watermarking obligations, for the transparency in 2026, and then even for the rules also for 2027 for certain high-risk AI systems. Our priorities are both to set up the governance scheme, and we are already very much cooperating within the office, growing now for also our future enforcement tasks as well, in addition to all the implementation work, having the close collaboration with the member states, the scientific panel, the stakeholders, and then also developing the guidelines, the code of practices, and some standards in parallel, in particular for high risk, as well as to engage broadly with the relevant stakeholders, including through an AI Pact initiative, different support actions we also run through sandboxes, AI service help desk that you will be launching also. Just to conclude, because it's an international conference for us, also international collaboration is key. It's one of the missions we have as the AI office, as the challenges are global, and we do value a lot, and we want to work a lot for cooperation on policy, especially also with like-minded partners, but also more broadly, multilaterally. And we aim to promote also our approach to trustworthy AI internationally through bilateral and multilateral forums. So just some of the examples of the international work streams. We do collaborate on the AI Action Summit and the Safety Summits. We've had the G7 Hiroshima process, the UN discussions, OECD AI recommendations, the first Council of Europe binding instrument also on AI as the convention, for which we've been also actively participating, the WIPO cooperation on AI, as well as discussions also between safety institute frameworks, and also a lot of bilateral cooperation agreements. So with this, I stop, and I thank you very much for the attention. We look forward also to further collaboration with all of you bilaterally that we have in all these various forums, and I wish you a productive discussion further at the summit.
네, 좋은 발표 잘 들었습니다. 이렇게 생성형 인공
Thank you very much for your insightful presentation. We heard policy initiatives of Korea, Japan, Singapore, and the EU in our first session, and now we will have a break before proceeding with the next topic. So please enjoy your break, and if you have any questions about the presentations just delivered, please scan the QR code on the screen and send in your questions. Those will be collected and delivered to the moderator during the panel discussion at the very end. Thank you. We will now begin the second session of Seoul Copyright Forum 2025. In this session, we will look at the creators and industry perspectives on Gen AI and copyright. So we will listen to the perspectives of Korea and the creators and the industries on Gen AI technology advancement and adoption. And as our first speaker, we have Attorney Ham Seok-chun, who is the president of the Choreography Copyright Society of Korea. Since his days as a judge, he has been an expert in deliberating many cases on copyright. Please welcome him with a big round of applause.
반갑습니다. 함석천.
Good afternoon. I am attorney Ham Seok-chun. I am currently the president of Choreography Copyright Society of Korea. I should better hold the microphone. Yes, today I will talk about choreography and copyright and also about AI. That is why I stand before you today, working as the president of the Choreography Copyright Society. I get these questions. Are choreography works copyrightable subject matter? Is there a copyright for dances? I answer them, yes, of course. Then why? For dances and moves and choreography not intuitively tied to copyright? It's because it was not as much an industry until now. However, at least in Korea, situation has changed. K-pop is pioneering a new cultural sphere worldwide and is scaled to a point where it can be called a market, and the revenue distribution system is what we are building. At the moment, being first in the world to do so. It all goes back to a hot summer day, August 29th, 2022. A group of choreographers started to speak out. Is choreography a creative work? Is a question with a very obvious answer, and why don't we watch a video clip?
굉장히 독특하다는 생각이 들어요. 이제 종이에다가 리듬 메이킹을 먼저 하고 안무를 진행을 하는 편이에요. 일단은 종이에다가 카운트를 이렇게 적어놔요. 1, 2, 3, 4, 5, 6, 7, 8 이렇게 적어놓은 다음에 예를 들면은 뭐 박수를 친다 그러면은 이렇게 짝대기 하나 그어놓고 아니면은 뭔가 느낌이 붕 이런 느낌이다 하면 동그라미를 그려놓고 뭐 세모를 그려놓고 약간 이런 식으로 리듬을 제가 머릿속에서 먼저 춤을 추는 거죠. 그렇게 그런 다음에 이제 연습실 들어가서 안무를 짜는 편이에요.
네, 이와 같이
So, after this creative process, you end up with this result. In fact, on YouTube channel, content file are some labels added onto some videos which cannot be streamed in real time. This is a policy of Google, and I think that is causing some glitch. So those who are streaming this event online may not be able to see this video. Talk to you about that answer. So there was a catalyst for my research while using the metro or taking the bus. I started to observe people, on the streets, in a bus or on the metro. Look at the people. It seems like they're listening to music, but actually they're watching music, be it as BGM for drama series or films or just simply enjoying music. They're always watching a dance video of the song that they're listening to. So the reason that they watch music is to enjoy the choreography that accompanies the music. So how significant is choreography in the K-pop industry? What would be your answer? I'm curious. Well, specific data would have to be collected, but I don't have a numerical answer for you yet. But I can say this. The significance of choreography in K-pop is huge. Let's move on. I would like to explain the progress of the work done so far. So I told you that August 22nd, in 2022 was the beginning of all this. It was to get feedback on the recommendation for attribution. It is important to know who the creator was for a work. So this was our aim, and we convened a congress, but it was not an easy matter, be it broadcasters or OTT. How should we let them know our stance that we desire attribution to be implemented? You might know Leah Kim from Street Woman Fighter Season 2, who was a big name in the choreography scene in Korea. She went to Jinju to consult an elder, and she teared up because she can never be acknowledged as a creator, even for her works, and she felt like she was wronged. So in December 2023, a recommendation for attribution was given to broadcasters, which was very fortunate. And in January 2024, WIPO took interest in this matter, the World Intellectual Property Organization, and they in fact reached out to us. So dance, going beyond choreography, but dramatic works and the traditional art sectors, which aren't standalone industries yet. Well, they were interested in listening to the voices of the members of these sectors. I was a judge back then, so I was not able to take part in the meeting, but engineers who are more well-versed in the matter attended the meeting. So we realized that even WIPO is interested in this matter. And April this year, at SCCR, they sought to add this as an agenda item, which is being supported by the MCST. And research has been done on registration of the copyright of choreographic work registration, and we will have another speaker come up with regards to that, because AI is employed when deliberating on the similarity of different choreographic works. And starting from last year, we created an association and started receiving signatures of K-pop choreographers. So after being incorporated as a nonprofit organization, we are seeking to be licensed as a CMO so that we could manage rights, just as we have that system for the musical rights. So we are trying to shape a revenue distribution system that hasn't existed before. So unlike film or musical works, choreography is distinctive in that while music is in the background, the creation itself does not have language. It's all body language. we do not use words or other language barriers. So I believe it will have a huge impact. And last month, we were incorporated as a nonprofit organization. And this is a very important moment in my presentation. I will be brief. I would like to thank the two agencies for all your support. I was quite surprised and very grateful that MCST and KCC together published this guide to copyright of choreographic works. The two agencies created this guide, and at the WIPO meeting held in April, I heard 59 countries attended, and this guide was, the essential parts of this guide was distributed to all of the countries. So about the choreography and the creative process and the revenue distribution are points of interest not only in Korea but in many other countries as well. Once again, thank you. And registration is enabled by AI. Since choreography is a subject matter of copyright, it should be registered. So for Berne Convention countries or the US, they have a different process. In the US, they need to have them registered in case of lawsuits, but under the Berne Convention, we don't need registration. But we should at least be able to register such copyright. That is the big premise. And all of the registration matters is overseen by a Korea Copyright Commission. And in the National Copyright Museum in Jinju, they created this booth dedicated for choreographic works. So once again, thank you. And I will now talk about the introduction of the registration program. Among the subject matter works for copyright, why is choreography tied so closely to AI? Well, in simple words, in the 70s or even throughout the 80s, information was carried through text. Text carried information. If someone wants to profess their love, they wrote a love letter. But then in 1990s, with the advent of emails, internet emails took over that role, and now most of the information is propagated through videos. So we would take video clips to even greet someone. I'm sure you understand that from 2D we're moving on to 3D. And among the subject matters of copyright, choreography is the only 3-dimensional work because it's spatial. Even films are consumed on a 2D platform, but dance, choreography is expressed in a 3-dimensional way. Due to technical barriers, while choreography is consumed on 2D platforms via video clips, but choreography will go on to lead the way as a work that is consumed through holograms, which is 3D. That's why choreography, which is 3-dimensional human being movements, from registration to similarity comparison, we need AI training. And for a more technical explanation, I would like to invite CEO and engineer Mr. Chun-ho Lee of Plesk to the stage. Please welcome Mr. Lee with a big hand.
네, 안녕하세요. AI로 모션
Hello, I am CEO of Plask Ijun-ho, and we use AI motion capture technology. As explained, music is written in forms of content standardized way with long history. But choreography was also expressed as pictures or via video clips or choreography scores. But video clips are 2D information, so it cannot retain the 3D geographical data. So what angle did the arms move in and how far were you standing towards the front of the stage are not expressed. The human movement related data has been digitized in the animation sector of the US, like by companies like Pixar. Such American companies try to capture the movement or gestures by leaving the rotation values as data, and I think I can elaborate further soon. And heavy sensors should be worn by the dancers in order to extract 3D data of the movements, and then using that data, how can copyright be retained and registered and protected is a question that we are trying to answer. Aside from storing the data, what features comprise copyright is also interesting. For example, for a musical score, it retains creative work, but it's difficult to compare them one-on-one because let's say there is this hit song, and if we double up the tempo, then we compare the notes of the two scores, then they will look like two completely different musical work. Or if we increase the key by 3 keys, then we'll recognize the song as the same song. But if we compare notes by notes, then the two might be seen as different music. So not only storing the data, but how to retain them after conversion is also important to research on. So if I start a choreography here, or if I walk over to the other end of the stage and do the same choreography by watching the other side of the wall, then the two choreography could be seen as two different choreographies, but scale, like the physique of the dancer and the starting direction, like do I dance here or in that corner, and the rotation, so which side am I looking at? These are some factors or conversion points that we should be able to employ when comparing two different sets of choreographic works, and that needs further research on. And swing is often a term used to describe the rhythmical play of the different dancers. And data needs to understand that that does not change the choreography in essence. If you don't overlay the two movements, then we will recognize that as similar movement, and that is how it should be recognized. But if you play the two different movements on the same timeline, then they may turn out to be different movements. But the system should be able to assess the two as very similar. So this is called time series analysis, which is heavily researched on. For example, dynamic time warping could be employed to compare two different time series data. And in a flexible manner, the two can be mapped and be deemed as similar time series data and sequence data. So if we employ such methods, while it seems to be similar, just with minor tweaks or ways of cheating, two choreographic works could be assessed as different, but we will be able to detect those cases. And now I will turn over the mic back to They say they split up the gestures, and this is a 4-count gesture. It's a very short move, but the Hanagami case infringement was recognized, acknowledged, because they saw the creativity in that short clip, and this became a very impactful case on this matter. And this is a very recent case in Korea. Kungtari Shabara should be familiar for all Koreans. Kang Won-rae, previous singer, created this choreography. All Koreans must probably be able to see it in their heads. So please read the text off the screen. Kang Won-rae became the first choreographer to be recognized in South Korea, and KB Financial Group was the opponent or defendant in this case, and copyright was recognized, and they ended up in a settlement. And that was a beautiful ending to this case. In the copyright sphere, when I'm together with K-pop choreographers, I always tell them that you can never enjoy culture if you are scared. Don't try to scare people by suing them. I always remind them of this point. If the public is scared or they think they could be unfairly charged, then they would just ditch that content. So, of course, protection is important, but creators should also be aware of where the public stands. And now choreographers have a deep understanding of that, and we have big boss entertainment companies in Korea who seem to be a bit scared due to choreography copyright. But as the K-pop industry expands, they are in a position to expect their profits to grow. That is all that I can say at this point. So after reaching a settlement, the case ended peacefully, and the attorney who was in charge of this case is now in the prosecution, so he could not accompany me to this meeting or this conference. Moving on, this video clip is quite long, so I will not play it here, but please remember to watch it afterwards. The reason I introduced this clip is to show that choreography is more than individual gestures. This is a mega crew mission where hundreds of dancers got together to work on this creation. So going beyond their gestures and poses, the arrangement, the placement of the dancers, using different height levels is something to watch. So creative elements could be more complex and more advanced than you might imagine. So please don't forget to watch this video clip. The copyright, as I understand it, is, I would like to coin this expression, I see it as a reservoir of revenue. In 2013, there was a very popular presentation. One man took an iPod up to the stage and said, all the music that you want to listen to for days will be stored here. And he went to visit a CMO for musical copyright rights and asked for the rights to 30,000 songs. And of course, he was rejected because just MP3 files of the different songs were illegally traded. But 3 promises was made. First was DRM, that it could only be played on iPods. Even as recently as 18 years ago, you had to plug in your earphones to your phones to listen to the music. And second was transparent revenue distribution. And the CMO thought, wow, this actually leads to remuneration, and suggested the other way around for Apple to take more rights for more songs. And starting from that point on, the public pays to listen to music, and copyright was paid for, and it led to creation of even better music. So copyright could be seen as a reservoir of revenue, and what's next? You have to connect pipelines to it and distribute that reservoir. So a tool that creates this entire ecosystem, the North Star for such system, the legal regime that enables that, is copyright. So why don't we apply that system to choreographic works? And we've seen huge progress, and MCST and KCC and the Copyright Protection Institute are heavily invested in this agenda and have showed us great support. And lastly, I will just read this sentence and go off stage. Creation through our bodies, the most beautiful form of art in the world. Thank you.
네, 함석정.
Thank you very much, Mr. Ham and Mr. Lee. Very interesting presentation. Now we're going to go on to the second presentation, which is going to be made by Mr. James Cheatley, the Vice President of the MPA Asia Pacific. He is in charge of promoting the creativity and commercial interests of its members in the Asia Pacific and the MPA. So let's hear from him how the global industries have to say about the generative AI and copyright.
Thank you. Since ChatGPT launched in November 22, I feel like all I've been doing for the last 2.5 years is talking about copyright and AI. And thankfully, that's something I quite enjoy. So it's great to be back in Seoul, and thank you to the MCST and the KCC for inviting me here today, and thanks to all the other speakers. It's been a very interesting afternoon so far. So I wanted to start my remarks today by showing two kind of dueling quotes that I think are emblematic of a positive and optimistic approach to technology in the creative industries and a more negative, pessimistic approach to technology in the creative industries, and then sort of tie that up into copyright. And both of these quotes are nearly 100 years old, which shows that these debates that we've been having about technology and creativity have been going on for quite some time. And I think it's useful to look to the past to help understand where we are today, and that maybe prepare us for the future. So what I'm going to argue today is that while AI technology is new and novel and throws up interesting and difficult questions, none of this is new in copyright law. And this is true for both inputs and outputs when we talk about generative AI. And technology has always been part of copyright law, and technology has always been part of the film industry. So let's start with the optimistic approach. So this is a quote, and sorry for putting all the text on the slide, I couldn't think of a better way to do it, but Paul Valéry was a French poet and theorist, philosopher, and he spent a lot of time thinking about art and culture. So here he is writing in 1928, optimistically, about the potential for technology to transform artistic practice. And so he writes, "We must expect great innovations to transform the entire technique of the arts, thereby affecting artistic invention itself, and perhaps even bringing about an amazing change in our very notion of art." Separately and elsewhere, he writes about the potential for technology to transform distribution and bring art and creativity direct into people's homes, which is what MPA members do nearly 100 years later. So Valéry represents a kind of an optimistic approach to technology in the creative industries. And Walter Benjamin, writing just a few years later, represents a kind of a more pessimistic approach. So he was a German theorist of the Frankfurt School, and he wrote a lot of things about a lot of things, but he also wrote about art and culture, and he wrote a seminal essay called "The Work of Art in the Age of Mechanical Reproduction." And in that essay, he responds directly to Valéry, and he says, with a kind of negative, pessimistic approach to technology. I mean, he was writing in a very different context. He was writing in Europe when fascism was on the rise, and they're about to start a Second World War. And so a very different context to Valéry. But in this essay, Benjamin's quite critical of this technology, and the technology he was critical about was technology that could take a painting and reproduce it in such a perfect form that a person looking at it couldn't determine which was the original and which was the copy. And so he thinks, well, what does that mean for art and society? And he says, well, what makes art important and powerful is basically three things. So artists and authorship, time and space. So essentially it's just, authorship and its context in society. And so since ChatGPT launched in November 22, I've been thinking about that essay quite a bit. Because what he says is that original art, that is an original work, that is created by an artist, has meaning because the artist gives it their aura. So if you take that a step further, what he's saying is what's important about art is artists. Artists make art important. Now, this is a copyright forum and not an art history forum, but it's interesting that Benjamin's endpoint is copyright's start point. So under all theories of copyright, utilitarian, Lockean, European, continental, they all start with an author and their work. The author gives the work authenticity. The artist gives their aura. And I'll come back to this in a bit. So someone wrote a book about moral panic in copyright about 15 years ago. And I don't think what we're talking about here is so much moral panic in copyright, but moral panic over technology. And we're not here to continue a copyright war, but I think there's a history war going on, one between optimists and pessimists over technology. So if you're looking at this slide, that is, and you don't know what that is, that's a music box and piano roll. And so this humble, innocuous music box and piano roll caused a moral panic over technology at the 1908 Berlin revision of the Berne Convention. So these Swiss music boxes and piano rolls were able to play music without musicians and play music without permission. And obviously that was a concern then. But over 100 years later, that's all been resolved and we still enjoy music today. Now that's just one data point and there are many other examples, but I have limited time and have to get through some other things. So what can we learn from this? That technology's always been a part of copyright law and that technology can transform creative practice. And our industry is one of technological innovation. Our industry has been innovating for over 100 years, going from silent to sound, black and white to colour, television broadcast, VHS and Betamax, DVD and more recently streaming. And the shift from digital to film production has transformed how content is produced, distributed and consumed, and all of which benefits audiences. So the history of the film industry is a history of technology, and AI is the latest iteration of this. And filmmakers have been using machine learning and AI tools for decades to improve the filmmaking processes. We believe that AI is used as a tool to enhance human creativity, not replace it. AI affords positive opportunity to enhance the filmmaking process and audience experiences. AI tools can free creators from some of the tedious and repetitive tasks that they've had to perform in the past and allow them to concentrate on the most creative aspects of their work. And we believe that AI will continue to help creators realize their vision to further enhance the viewer experience, making visual effects more dramatic, more realistic, and more enjoyable for audiences. And like all other technologies, technological innovations that have happened before AI, AI will enable experiences that haven't previously been possible. So there's a lot of talk out there that we're on the cusp of a new golden age of content driven by AI. So coming back to copyright, we ask what is an author? So I'm assuming this is a copyright forum, so everyone knows what this monkey is, who this monkey is. It's the most famous monkey in the history of copyright, and this photograph changed copyright forums and discussions about authorship for the rest of the time. Anyway, so this is a monkey that took a photo of itself. A British photographer went to Indonesia, went to the island of Sulawesi, and he wanted to photograph these black-crested macaques, and the monkey took the photo and then took the camera and took a photo. Wikimedia subsequently put the photo up on Wikipedia. The photographer, David Slater, sent a takedown notice alleging that he owned the copyright in the photograph because it was his camera. Wikimedia said no, because the monkey took the photo, there's no copyright protect in the photo, so therefore we can do as we like with it. So returning to Benjamin, what he says what is important about art is artists, and that's what we say about copyright. We don't say monkeys are important, we say humans are important. And so in all civil and common law copyright jurisdictions, the author is the starting point. But that's not a monolithic position. So some Commonwealth countries following the UK have to protect computer-generated works, and in our region, that's New Zealand, India, and Hong Kong. And the Hong Kong government has gone as far as to say that all generative AI outputs will be protected by copyright as a computer-generated works. As Gavin was talking about earlier, in Singapore, authorship is only required for non-authorial works, but for authorial works, but for non-authorial works, so films, broadcast and sound recordings, they don't require authorship. And that position was actually adopted from Australia's copyright law, so Singapore copied Australia's Copyright Act, word for word, pretty much, in the 80s. And then similarly in Australia, works such as literary, dramatic, musical and artistic works all require authors, and films, broadcast and sound recordings do not. So the question posed by generative AI is, should AI outputs be protected by copyright, and if so, who should own it? And we say existing law is sufficiently flexible to deal with these questions. They're interesting questions, but they're not new questions, so as the monkey shows us, and that photo was taken about 13 years ago. So on the input side, there are essentially three ways to use copyright: under a license, under an exception, or in the absence of those two things, it's an infringement. And I'm going to talk about these things in turn. So licensing for AI is happening, and it's accelerating, and this is a good thing. And I think it's happening mostly for two reasons. One is obviously to avoid the risk of infringing copyright. You get a license to avoid that risk. The second reason, I think, is that there are valuable data sets that are not publicly available, that haven't already been hoovered up by the large LLMs, that sit outside, that they're not publicly available, and the only way you can get lawful access to these data sets is through a license. So this is all happening, and it's all happening, and this is good. And licensing is the key to the film industry. So there's a norm in our industry called chain of title, where if I'm a distributor and I want to buy some content from a producer to distribute, say in Singapore where I live, I want to commission or get a Korean producer to sell me the content so I can distribute in Singapore, I get from that producer a chain of title and indemnities and warranties that the producer has got all the necessary rights to sell me that content. So because in a film, there's not just the film that is protected by copyright, but there's the script, there's the acting, there's music, there's all these other copyright inputs that go into the film. So chain of title says that the person that's selling the content has got all the necessary rights. And this is important because I'll come back to it in a bit. But licensing is a key to the functioning of the film industry, and I think it's likely to become the functioning of the AI industry as well. So how do I go back? So now lastly, exceptions. So our view generally is that exceptions should not interfere with licensing markets, and that's essentially the three-step test. Also, exceptions are limited in that they're territorially bound. In a global digital marketplace, that can create issues for cross-border infringement. And it was interesting listening to the EU earlier, because the EU AI Act sets up some interesting cases around border access or market access. For example, in Europe, opt-outs must be respected, and the EU AI Act sets up market access rules for that. But let's say Singapore, for example, its TDM exception does not have an opt-out for rights holders. So question whether a model developed in Singapore would be compliant with EU law, not sure. So there are some exceptions in the region. So Japan and Singapore, and we heard about the Japanese exception earlier. We heard about Singapore's exception too. I think reasonable minds can differ which one is more permissive. Professor UENO said that Japan's a machine learning paradise. I would argue that perhaps Singapore is perhaps more permissive than Japan's, and I would also suggest that rights holders don't necessarily think that Singapore's exception is sufficiently permissive. I think they think it's too permissive. So the EU has 2 exceptions, and they ran through that earlier, and the UK has one, and there's been a bill passed by the UK Parliament just last week covering this issue. So, and there are countries in our region that are actively considering exceptions. But I think it's interesting if you look at the direction of travel. So there's a world pre-ChatGPT launching in November 22, and there's a world after it. And the direction of travel before November 22 was more permissive exceptions. And then the only government in our region that has put forward a coherent kind of policy on a text and data mining exception is Hong Kong, and they have gone a more restrictive path. They have proposed 5 conditions on their text and data mining exception, and they say that is to make it more 3-step test compliant. They've said that they want to pass legislation in the first half of this year, which runs out in a couple of weeks, so we'll see if that happens. But it's an interesting data point, and no other government in our region, in the APAC region, is far along as Hong Kong. And lastly, I talked about the last way to use copyright is in the absence of an exception or permission, and that's infringement. And again, we don't see the need for changes here. The test for infringement is largely universal. It's about access to the content and substantial similarity. These are very technologically neutral tests, and it's fact-based, and this is both on the input and output side. We don't see any changes needed. So if you take a step back and look back at the last 2.5 years since ChatGPT launched, and focus the world's attention on generative AI technology, what's happened? And a pragmatic view could be that the market is responding to a new technology as it should, as it is expected to do. So setting aside some of the non-copyright issues around the potential for harm that can be done through misusing the technology, and that's important, but that's not really a copyright discussion. What is happening is the market is responding as it should. So there are some players that are engaging in risk, and the consequence for that, risk appetite, is that they're getting sued many times over in the US, in Korea, in India, and elsewhere. Others, like in our industry, Adobe and Runway, are not engaging in that level of risk and are getting licenses. And in our industry, that's really significant because it comes back to chain of title. So there are AI tools that, like Adobe Firefly, that can be used with certainty in our industry because Adobe has said we have got either licenses or we're using public domain data sets. So the inputs are clear, so that means your outputs are also clear, and they give indemnities and warranties that if there's anyone comes forward for infringement, they'll adopt that responsibility. And so to further this point a little bit, I think with every license deal that's being struck and every infringement claim that's being filed, the scope of fair use gets kind of narrowed a little bit, and also the argument for text and data mining exceptions gets weakened. So the market is responding as it is expected to do. And we think there's no need to rush into any legislative reform, as copyright is almost uniquely placed, and it's set up well to deal with these new technologies. So So we believe that copyright must be respected in AI, just as in all other aspects of our industry. Copyright law is dynamic, technologically neutral, and has been sufficiently flexible to accommodate a host of new technologies since its origin. It's a robust framework and is equipped with tools to deal with new issues that may arise from using new technologies, including AI. We believe in a human-centric creativity because humans are and will always remain at the heart of the creative process in storytelling in the film and television industry. We embrace innovative tools, including AI-enabled tools, because they allow human creators to give life to their creations, making for better content and better serving audiences. And so, in short, we're really optimistic about the future. And in conclusion, in copyright, as much as things change, they stay the same. Thank you.
네, 좋은 발표 잘 들었습니다.
Thank you for the very fruitful presentation. We heard about the stance of different Asian countries and the strengths and sufficiency of the copyright framework that is already in place. Once again, thank you very much, Vice President James Cheatley. Now we will move on to the last presentation of session 2, and we have Ms. Rachel Lee from AWS APAC Hub, who is in charge of competition, consumer trust, and AI policy. She will talk about generative AI-driven media and entertainment innovation and promotion of creativity. So she really put in a lot of effort to perfect her presentation materials, so the slides may show some differences than what you can see in the booklet, so please bear with us. Then why don't we welcome Rachel Lee, Head of Economic and AI Policy of AWS Asia Pacific Hub.
안녕하세요. Good afternoon to Director General Jung, Chairman Kang, and esteemed guests from around the world. I would like to extend my deep gratitude to the MCST and KCC for this invitation to address this excellent crowd before us, and my congratulations to you for securing an excellent lineup of speakers who have come and spoken before me. My name is Rachel Lee. As has been announced by the MC, I am the Asia Pacific Head of Economic and AI Policy at Amazon Web Services, or AWS for short. In my role, I have had the privilege and opportunity to have many conversations with governments, policymakers, and thought leaders across this region to talk about how we can harness the potential benefits of AI and bring about benefits to APAC. Some of the common themes in my conversations that have come up is, firstly, how can we use policies, including copyright policies, to break down any barriers in AI adoption? And secondly, how can each country be globally competitive and build the most conducive environment for local companies to adopt AI and thrive and scale globally? AI is the most transformative technology that we've seen since the internet. It is already changing every customer experience that we know at AWS and leading to an unprecedented amount of innovation. I'm one of the optimists, and I believe it is bound to bring new innovations that we haven't even thought of yet. Amazon is investing heavily to make AI technology more widely available, enabling innovation to flourish at every stage of development. For example, we've pioneered a service known as Amazon Bedrock, which would enable our customers to experiment with different leading foundation models. We have also designed custom AI chips and have dozens of AI-powered applications launched or in progress. We are so excited to see how our customers will use Gen AI to create significant business value and therefore value for consumers, whether that is in radically improving productivity or innovating to create new experiences or ideas to improve the lives of consumers. At Amazon, we are no stranger to AI. We have been using AI. We have been using AI expansively across the company for the last 25 years, delivering meaningful improvements and significant benefits to customers, partners, and employees across the economy, changing the way that we do our jobs and the way that we live our lives for the better. You'll see it in every single one of our businesses: stores, advertising, devices, entertainment. AI fuels our personalized e-commerce recommendations, or if you've been to the US, Rufus, our expert shopping assistant. It drives the pick paths in our fulfillment centers. We have it in our Amazon Go stores. We have it in Alexa. We have it in Drones Prime Air, our drones business, and Amazon Pharmacy. And beyond its application within Amazon, there is so much more to be excited by. AWS commissioned a study by Strand Partners on Europe's AI potential. And this study found that every minute, somewhere in Europe, more than 5 businesses are adopting AI for the first time. This translates to an AI transformation that is happening at breakneck speed. Nearly 3 million businesses across the European continent are adopting AI in the past year. And this will put mainstream universal adoption within reach by 2030. This alone outpaces the early growth rate of adoption of game-changing technologies like mobile phones in the 2000s. And we're going to see this transformation take place across all sectors. From the healthcare sector, where we are seeing some of the most promising applications of AI technologies to make a tangible impact on people's lives, perhaps through improved diagnosis, better drug research, to the tech sector, and the agriculture sector, and the education sector, and the finance sector. And it will also improve how governments are interacting and rolling out public services for their citizens. For example, AI was used to develop early warning systems for flood risks, which will protect 700,000 residents in a city in Spain. At Amazon, we've built an AI stack that makes adoption dramatically easier and kickstart these transformations which I've just spoken about. At the application layer, we have tools like Amazon Q, which provides AI-powered assistance across various business functions. This means that companies can start benefiting from AI with very little technical expertise. In the middle, we also have our AI tooling layer with services like Amazon Bedrock, which will allow organizations to build custom AI applications using pre-trained models and APIs, without themselves having to build their own software tools from scratch. And finally, but not least, our infrastructure layer, which provides that raw computing power needed to train and run AI models at scale. Now, what this means is basically you don't need to have a PhD in computer science, or if you are a small business owner, you don't need to hire an army of technical experts or data scientists to benefit from AI adoption. A small manufacturer can easily use AI for quality control. A local retailer can use AI for inventory management, and a startup can deploy AI chatbots for customer service. But we are here at the Copyright Forum today, and I do want to speak a little bit about the transformative capability of AI in the media and entertainment industry, particularly with the ability of foundation models to read and generate multiple formats of media, from video to images to text and audio. Over the next few years, we will see use cases where foundation models will be able to assist with every category of media and entertainment workloads, whether that be content production to media supply chain and archival. And no AI presentation is complete without talking about use cases. AWS is proud to work with NFL to improve fan experience using generative AI. NFL is using AWS services to build a product which will quickly surface historical play details. They are also using AI to upscale and improve historic game footage for archival purposes. And they are using AI to create a knowledge base that will answer technical documentation and production guideline queries. So the next time you're watching a video at home, an NFL video, and you're thinking, whoa, how come there are some interesting facts about your favorite players or your favorite teams, such as when has this player had a red zone touchdown? Know that this is powered by AI, and making sure that you remain engaged throughout the game, NFL is using Gen AI tools to come up with these informative fun facts. And it's not just our models, which our customers have available on Amazon Bedrock. They also have access to other leading model providers, including Anthropic's Claude models and Stability AI's Stable Diffusion. Content creators can easily access image generation models to create images such as this concept car, which could work both in air as well as in water. And the applications are endless. These image generation models can be used for the creation of storyboards, just using text prompts. And maybe since we're here in Korea, bringing a bit of local flavor, you may be familiar with LG's award-winning AI artist, Tilda. Tilda had a big debut in New York Fashion Week, where it won a couple of awards there. And I'm very proud to share that LG had built its foundation model from scratch using Amazon SageMaker. A couple more exciting, fun use cases, and I think this goes back to the point that James made about how AI can enhance artistic visions. I think audiences here may be familiar with the Oscar-winning movie Everything, Everywhere, All at Once. What you may not have known was that the visual effects team that created the scenes within the movie had used AI to help in that process. So Runway AI's model was used in the movie to create multiple parallel universes, more complex scenes, and realistic visual effects to blend with the live action actors and actresses. AI was also used to remove the green screen backgrounds from images or videos. Now, another unrelated point, I'm also quite excited about how AI is going to help with the creation of art. Every time I travel around the world, I try to make time to stop by local art museums. And the next time, if any of you are in DC, I highly recommend going to the Smithsonian. This is an AI-powered sculpture which uses AI technologies to allow visitors to create art with their voice by translating spoken words into patterns of color and light. In order to translate words into colors, AWS engineers trained a word embedding model and taught it to associate certain words with specific sentiments. So if you went to the sculpture and you shouted, "exciting" and "bright," that would be associated with a positive sentiment, and the sculpture would emit a specific pattern of light and colors designed by the artist to match that sentiment. I am, as I mentioned, an optimist, and I'm very excited to see how AI will enhance the work of artists and help them to bring to life their artistic vision across multiple mediums. But let's get back to the part of the presentation that we talked about at the start, which is what is the role of policies in driving more AI adoption. According to research done by the OECD, Korea is amongst the global leaders in AI adoption at approximately a 28% adoption rate. This means good things for Korea in terms of increased output and productivity gains and your overall economic outlook. But things can always be better, and sometimes that goes towards this very important topic for today, which is how copyright policies can help drive greater AI innovation. And I wanted to draw on an example from my background as a Singaporean. I'm really proud of the work that AI Singapore is doing to create Sea Lion, which is a family of open source large language models that better understands Southeast Asia's diverse contexts, languages, and cultures. This stemmed from a recognition that existing large language models are trained largely from English language resources. Sea Lion was intended to cater to an underrepresented group of population and was trained more on content in the Southeast Asian language, such as Thai, Vietnamese, and Bahasa Indonesia. One interesting reflection I saw when the work on training Sea Lion was ongoing was this tension between data sources and the quality of the model. When talking about the data sources used to train Sea Lion, AI Singapore mentioned that they took a very conservative approach, as you can see from the slide, and conceded that this would have a corresponding impact on the quality of the model. And as you can see at the end, our models will not be as good. Now, this really underscores the importance of having legal clarity to guide training behavior. And it really goes to the heart of that issue between what is the country's ambitions or AI ambitions, and how can it help its companies be globally competitive? These considerations and respective trade-offs are equally relevant here in Korea. Much like Southeast Asia, Korea operates with its own local language, its local cultures and values, and local context. As we see more Korean companies strive to build their own globally competitive large language models, I think Korea will face this similar question of what role does a copyright regime play in enabling Korea's overall AI ambitions. And this brings me to the heart of the question. I think there are three principles which I wanted to discuss on today's stage. The first point is that legal clarity will be essential in seizing the AI opportunity. Legal clarity will help drive domestic innovation and adoption of AI and attract investment in local computing infrastructure. Amazon believes that the best way for a country to become a global leader on AI is to provide legal clarity through a text and data mining exemption that training AI models is not an infringement of copyright, where the materials have been accessed lawfully. To be effective and compete globally, the truth of the matter is that models need to be able to train on broad data sets. In order for this training at scale to take place, companies would benefit from a robust legal basis for that to happen. This text and data mining exemption would also reflect a commitment to the long-standing principle that copyright protection should not inhibit the exchange of ideas or knowledge, and make clear that copyright was not intended to protect the ideas contained within a work. Now let's take a more analog experience. We'll forget about AI for a moment, and we go back to the kind of first principles when it comes to copyright. It protects original expressions fixated into a work. And it prevents, for example, someone reading a book and reproducing it verbatim. But it was never intended to prevent someone from reading a book and then being inspired by the ideas or writing style within that book, and from learning facts and figures and applying that knowledge in the future. Using another example, a musician who teaches themselves to play a catalog of existing songs and then uses that accumulated knowledge to learn how to create new music isn't breaching copyright, unless and until they actually produce a specific song which infringes upon the copyright of others. This same distinction is true for AI models, which learn how to perform certain actions by analyzing the data upon which they are trained. Now, of course, we recognize that segments of the creative community have expressed concerns with the adoption of a text and data mining exemption, and we appreciate that governments are thinking of ways to balance the rights between AI developers as well as the creative sector. We encourage governments to think about this caveat, to approach caveats to text and data mining exemptions with some caution, as there is a risk that policy runs ahead of what is technically feasible at this point in time. It would also render AI development very challenging. General-purpose AI models are trained on hundreds of millions, if not billions, of pieces of content, and the value of any single one to a final model is truthfully minute. Any framework that seeks to enshrine a right to opt out or mandate licensing requirements on publicly available data faces currently insurmountable hurdles. For a piece of content, which as a reminder has a minute impact on model performance, there are disproportionately high transaction costs involved in identifying the owners of freely available online content. It would also be very challenging to manage disputes relating to ownership and provenance, and then negotiating contracts for a potentially billions of pieces of work to train a model. Much of the conversation has been around the role of global technology companies, but think back to that slide about AI Singapore and of Korean companies which are trying to create globally competitive Korean large language models and startups. These are the companies which will not have the resources to engage in these lengthy legal battles. And a framework like that may inadvertently hold AI progress to ransom. Legal clarity would also serve to set Korea apart and unlock opportunities for creators to monetize their works for use in AI, and encourage more AI developers to operate here in Korea. We and other major AI developers are already licensing content to train our models today. Now, the second principle, which I think is very useful to talk about, is to protect the principle of territoriality in copyright. Regardless of the approach governments around the world choose to take, it is important to ensure that no changes to copyright law or additional components like transparency reporting break with that long-term precedent that copyright is a domestic matter. Any move to make laws apply extraterritorially would make that country a global outlier and increase the friction and cost of operating AI services. It would not only deter investment in AI development, but introduce that very real prospect that AI products and models experience delayed launches or are withdrawn completely from that country. And finally, a third principle that I wanted to talk about was to defend copyright appropriately by increasing controls on copyright infringing outputs. Amazon believes that the best way to protect what copyright was designed to protect and preserve AI innovation at the same time is to focus on the outputs. Where an AI product is used to reproduce copyrighted material, these outputs may infringe copyright protections. Those infringements are subject to copyright law, and it is imperative that responsible AI developers and users of AI systems work strenuously to avoid them. Governments could make any TDM exemption from copyright contingent on AI developers implementing safeguards to stop copyright infringement outputs. Alongside a requirement that all materials are accessed lawfully, this would provide comprehensive copyright protection to rights holders. Furthermore, it would enhance trust in Korea as a safe regulatory environment for AI training. Now, I've spent much time today talking about the economic and wider societal benefits that will accrue globally across both creative and AI sectors. It's imperative that we get the copyright framework right to avoid jeopardizing those benefits. As a company, we are laser-focused on AI's immense potential, and we think that it will bring benefits to the creative industries alongside other industries globally. AI developers today work hand in hand with creatives to help them reach consumers, further monetize their works, and create in new ways. But in order to reap those rewards, capital investment on data centers, chips, and other hardware is actually needed right now. Regulatory uncertainty or a framework or regulatory setting which is too restrictive will dull a country's attractiveness for investments and expertise at this critical time. I hope the points I've raised in this presentation has given you much to think about. I look forward to a more productive discussion as we go into the next day. And I look forward to any fruitful discussion on the finer details of my presentation. Thank you very much for your attention.
Thank you very much. She has been talking about some of the infinite benefits from AI, and she has also given us some 3 things that we need to be aware of. So she has been talking about the appropriate balance that we have to strike, that we have to think about in Korea. So I'd like to thank Ms. Rachel Lee once again. So we've had 2 sessions and 7 presentations. So I would like to thank the speakers once again. A big round of applause for all of the speakers. Now it's time for us to entertain some questions and have a panel discussion. While we are rearranging the stage for the Q&A, I would like to ask the participants to scan the QR code and you can post your questions there. Those of you who are watching online can also use the QR code to scan it and to upload your questions. We will do our best to rearrange the stage as quickly as possible. I'd like to ask for all of you to bear with us for a few more minutes.
네.
Now we have about 60 minutes for our overall discussion and Q&A. I would like to ask the moderator and also the speakers to come up to the stage. Professor Seung-jae Choi from Sejong University, Ms. Youngjin Choi from the MCST, Mr. James Cheatley from the MPA, AP, Mr. Gavin Fu from the Singapore IPO office, Ms. Rachel Lee from Amazon Web Service, AP, and Professor Tatsuhiro Ueno from the University of Waseda, and Mr. Seok-chan Ham from the Choreographic Copyright Society of Korea. Please come up to the stage. Thank you very much. Now, we are going to invite Professor Seung-jae Choi of Sejong University, who has been researching in patent law and copyright law and other IPR-related law, and also the fair trade law. So I would like to now give the microphone to the moderator.
Yeah, it's my pleasure to make this good discussions with the expertise and distinguish the professionals from different countries. My question will be, 6 up to now. Actually, if you have further questions, actually please upload your questions through the system. So my first question will be ascribed to the Choi Young-jin. Before I make my question, actually I was asked to ask questions in Korean because the questions will be translated into English simultaneously. So I will ask questions to the discussant in Korean. So first question.
So the first question goes to Director Choi Young-jin. When TDM exception was introduced, was it coupled with the training data disclosure requirement in order to alleviate backlash from right holders?
네. 지금 워킹 그룹에서 관련된 논의를 하고 있는데요.
The working group is discussing the matter, and when introducing TDM exemption, disclosure of training data should be set as a premise, is the opinion. And we weren't able to discuss this heavily in the first half, but it will be discussed in the second half of the year.
I want to ask Mr. Gavin Fu. How about your opinion regarding the question number 1? Actually, the question was, if we Korean, the copyright wanted to introduce the TDM exception as a part of our law, so the transparency, the requirement has to be introduced as well as the TDM exception. That's the kind of question ascribed to the Choi Young-jin. How about you? You please share your ideas and comments to the question number 1.
Yeah, so as I already mentioned during my presentation, these transparency obligations are not part of our copyright regime. For us, we see this as part of the AI governance issue. It's something that is handled by another ministry in Singapore. But we think definitely these discussions will be relevant. Especially when so for us it's a little bit different, right? We introduced the exception first, and subsequently that's when a lot of these discussions about transparency for data sources came into force, have been prevalent, right? Whereas for Korea, you're at this stage where you are discussing the introduction of the exception in the first place. And so I think you also have the opportunity to consider whether it's suitable to be introduced under the copyright legislation or a broader, some form of legislation or governance requirements on AI. I think some of the relevant considerations, at least for us, in saying, hey, why is this more suitable for AI governance? It's because when you, for example, for AI developers who disclose their data sources, that sort of information is not only relevant for copyright, it's relevant for users or other downstream developers to know that the AI has been ethically trained and so on. So I think maybe that's one way you can start thinking about it. Yeah.
Thank you. 예, 감사합니다. 지금 우리 싱가포르
Thank you very much. Mr. Gavin Fu from Singapore said that the TDM can be legislated first, and then there could be some complementary issues like transparency that can be discussed. But then when we talk about transparency, it does not necessarily has to be regarding copyrighted works. It can actually be adopted in a more broader context.
Any comments on the question number 1 or?
It's working? Okay. Regarding the transparency obligation, we have no such obligation, not only in copyright law, but also in AI-related legal mechanism. But I think it would be a good idea to introduce an obligation for transparency regarding the origin of the training data. So to take a proper balance between copyright holders and AI developer, even in Japan. So I think that would be a good idea also in Korea.
Thank you, the Ueno Sensei. Actually, the Ueno Sensei has a number of other questions, so actually we have to spend some time for the further, the answers. And do you have any comments? It's time for the Mr. Cheatley.
Oh, okay, it's working. Great. Yeah, the way we sort of view this transparency issue, there's kind of two separate issues. There's the copyright one, which is essentially about supply chain transparency to the copyright owners and the nature of that. And that's not so clear, even in the EU, how that's going to work in practice. And then there's a second sort of form of transparency, which is about consumer-level transparency, that consumers at a content level that are watching content are informed about the nature of the content and whether it's as being used in the making of that content. And on that, we have a view that countries should be careful with the labeling obligations, particularly for creative works. Korea's basic law has this kind of exception for creative works because essentially when you're using AI, there's AI in everything now, and in film production, and I gave some examples, and it would completely, disrupt the audience experience if you had to disclose at various points in time that AI was used in the creation of the content. So they're two separate issues, and I think it's important to be able to not conflate them because it can get very tricky very quickly.
Oh, thank you. Actually, you have wonderful points on the transparency issue. Actually, before we move to the next question, Ms. Lee, do you have any comments on the transparency issue? Because actually, you may have something about some comments on the transparency, maybe.
Yes, thank you very much. We at Amazon have 8 pillars of responsible AI, of which one of them is transparency. That motivated us to publish information relating to our AI services through AI service cards since November of 2023. I think I echo Gavin's point about sometimes these transparency measures are not just related to copyright, but there are issues relating to transparency from a responsible AI perspective. So I won't add on to what Gavin has said, but I will add one additional point, which is I think for countries to want to be globally competitive when it comes to the AI ecosystem, they should strive to have regulatory systems or frameworks which are internationally interoperable with each other. So where there are already existing standards or existing requirements to disclose information or to label information, it would be an outlier for Korea to take an approach which goes beyond what already exists within the EU AI Act or within other jurisdictions. And that would affect how Korean companies would be able to scale their products or services globally and import them or export them out to other countries.
Yeah, thank you. 잘 들으신 것처럼.
Yes, as you have heard, this issue of transparency is related to Copyright Act in one part and some parts aren't. And in the EU's AI Act, this transparency issue was introduced. So with regards to that, we will take all your comments into consideration for further legislation. Thank you.
With the question to the 우에노 센세. 향유 목적의 경우에
So in the case of use for the purpose of enjoyment, how would you actually be able to determine the intention if a person had intentionally created an output that's infringing copyright or not? So you would need objective factors to be able to determine that, right?
Thank you for questions. It is important to how to determine the intention of AI developer. So as I mentioned before, if you intended to generate copyright infringing content in the training stage, so Article 34, the Japanese CDM exception, does not apply to such kind of training. But how to prove the intention? The important is to know the purpose of AI training. So it is very complicated. So, but according to the guideline, it is also possible to prove the intention or the purpose by objective situation. So you can determine the intention objectively. So if you the AI developer has based on the surrounding situation, it is also possible to prove objectively the intention. So in this case, Article 34 is not applicable to the training data set. So I hope that.
You mean actually there's still the intention of the copyright potential copyright. You mean actually still the copyright infringer's intention is important, even actually in the case of the AI machine learning situation. Is it correct? And then actually that kind of intention has to be proved by some kind of objective factors, some kind of objective indicia, such as circumstances of the infringement or other, the objective, the requirements is necessary to prove the infringement of the, the TDM exception. That's the kind of abbreviation when you explain to the question number 2. Is it right? Or do you have some more comments?
No.
That's all?
Okay.
Okay.
Yes.
Then actually, if that is the Singapore, do you have any kind of intention? Is it necessary to prove the applying the TDM exception to the copyright infringement case, Mr. Pu?
No, there's no such requirement for intention.
No requirement for intention. How about the industry perspective? Do you have any comments on the intention requirement in the TDM exception of application?
No specific comment on intention. I just want to say maybe one comment on the non-enjoyment factor. Non-enjoyment is a feature of the Japanese text and data mining exception, but just because the content isn't enjoyed by an AI company, it doesn't mean that it doesn't have value. So, and it's interesting you brought up the Studio Ghibli example, because when OpenAI launched that Studio Ghibli effect, they gained a spike in subscribers that rivaled their launch date. So there is a value there. It's just maybe not couched in enjoyment.
Okay. Mr. Ham, actually, as a judge, actually, you have some kind of, the chances to look at the, the intention of the potential infringer, right? So can you share some experience with us?
고의라고 하면은
So when you say intent, it means it's not subjective thoughts in our minds, but it has to be able to be proved with objective evidence. So in many cases, I think I have 2 points to share. First is the prompt. That is the human input. And when you get the output, then publicizing or publishing that output, making that determination, the publishing right, which is part of the author's moral rights, is still something that human beings can exercise. And what I mean by that is when a person acts in a certain way and makes certain actions, some are intended, some are mistakes. If you look at the overall time series of the actions taken, there's a mix of what's intentional and not. But if you compare where you started and where you end up in, if there's intent of infringement, then that is an important point to be considered. Thank you.
질문이 아주 프랙티컬한 질문을 해주셨는데요. 우에노 선생님께서 일본 저작권법 30.
There were some practical questions, and so Professor Ueno has talked about Article 34 and the AI output and its possibility of infringing copyright would also depend on the intent.
Actually, they will ascribe to the Professor Tatsuhiro Ueno. The question is, AI로 하루에 1조 개씩 출력.
So the AI will be able to create 1 trillion pictures in a day, whereas a person may take 2 weeks to draw 1 picture. Can the two sides actually compete? The second part of the question is, so I am a personal illustrator who earn money by drawing in a particular style. But then if we say that a style cannot be protected by copyright, then people like me won't be able to earn a income. And so an AI can be used to disrupt people like me. So an AI can be used to create and generate images en masse in my style and then can be distributed for free. So what do you think about this kind of situation?
Okay, thank you for your questions. And I basically agree that if an generative AI generates a tremendous amount of contents which are similar to the original work in the style, it is true that such kind of AI output will compete with the original work. And that would harm the creator's interest. But the question is such an interest is protected by copyright or not. The copyright protects the original expression, not the style or idea. So such kind of a style or idea is not subject to copyright protection. So in my opinion, even if the tremendous amount of AI outputs would harm the original creator's interest, but such interest is not protected by copyright. So that would not violate the three-step test, or that would invoke the proviso of the Japanese tedium exception. Yeah. Okay. Sorry. And but if I'm not sure if I could understand correctly the question, but according to the questions regarding the hostile outputs, so if you generate a large number of hostile content to the original creator, so that would raise another legal issue. So even if such kind of AI output doesn't constitute copyright infringement, that can be taught in civil law in Japan. Recently, there is a discussion, even if an act doesn't constitute copyright infringement, but it can be taught in civil law, general civil law. So maybe you can demand a damage against the infringer, so, and not in copyright law, but in civil law in Japan. So that's my conclusion.
Thank you. Actually, in some, the copyright law may protect the kind of style of the some painter, but actually still in case of Japan, the general civil law may apply in case of the mimicking the style of the some painter. If it is the case in Singapore, what would be the result? Let's say let's take the example of the Ghibli. Actually, if that kind of mimicking the style of the Ghibli in Singapore, then what would be the result?
Yeah, so the position under Singapore law is quite the same as in many jurisdictions. We generally don't protect style. So it really depends on the specific infringing output, and you need to compare that output against an existing work by Studio Ghibli. But I wanted to also take this opportunity to address that question about how do these two sides compete. I think the question is, with generative AI, you can generate works really quickly, whereas a human artist might take a very long time to create that work. I think there are two perspectives to think of here. First, I think we must recognize that with generative AI, some industries may be more affected than others. To some extent, what we've heard is that when you're doing things that are more mass-produced, some stock images, these sort of things, they may be more affected, whereas some creative work such as fine art, these sort of things, they may be less affected because they're very much about specific human output, and sometimes the reputation of the artist can contribute to the value of the work as well. And that's the second point, I think, something we need to think about, as if, with AI-generated output being so prevalent, will we come to a stage where actually there is greater value in something that is created by a human being? Because that there are things that are involved in the creative process by a human being, an artist who puts his soul into that creation, something you'll never get with generative AI.
Okay, thank you. If it will happen, it's a hypothetical case, but actually in Korea, what will be the result, Mr. Ham? Can you share your ideas with us?
굉장히 어려운 질문을 이렇게
This is a very challenging question, as we have a very high-level expert audience. Will we still have that discussion ongoing, AI outputs, AI-generated outputs based on data, and what is that data? Well, when it comes to those outputs, it should have minimal level of creativity, but should not be plagiarizing outputs. So it should be something made, not copied. Is there originality? I think that is a criteria to be considered. The resources used by AI is a point where countries have different approaches. Japan and Singapore, I think, is taking a more tolerating approach, whereas there are lawsuits ongoing in the US when New York Times first sued OpenAI, and with the Writers Association and the Video Association has a suit against OpenAI. And the three broadcasters in Korea are preparing a suit against Naver. And well, we will be facing the question of, is it infringement or not? And to answer that, we have to refer to the Copyright Act, where does it have minimal level of creativity, and is it a copy or not? I think that is where the solution lies.
Like OpenAI, actually they gain more than 5 billion subscribers by using the Ghibli style, the animation style, the pictures or things like that. So if that is the case, then actually what would be the stance towards that kind of situation by the MPI, Motion Pictures Association, MPA? I'm sorry.
Yeah, look, I think it's a really interesting question. And I think there is potentially a role for moral rights here. That it's kind of adjacent to copyright. And maybe that's something for consideration here. But yeah, no, it's a really tricky one. To protect a style, it doesn't really fit in copyright. There are other sort of mechanisms that have been sort of identified here. But yeah, I think moral rights is worth a look as well.
Moral rights issue, like Simpson style, Okay. How about Ms. D?
Thank you. I have a couple of thoughts on this question. My first thought was in relation to a point which I made in my presentation of actually the exemption might help this artist to be able to monetize the illustrations that he or she makes, in the sense that that artist can then license that material or those illustrations for training by AI models, or they could choose not to if they so decide. The other point to also make is, I think this question belies a feeling that it's artist versus AI. But one of the things I would encourage the group to think about is actually how can AI enhance the work of the artist? How can AI actually help this artist be more productive? That instead of using hand to illustrate maybe just one item per day, to consider using AI to automate certain aspects of it and to be able to produce maybe 10 pieces of art in a single day.
Well, actually, you focused upon the kind of responsible AI issue, right? So actually, from the responsible AI perspective, that kind of mimicking the style of some famous painter such as Goho or like a Ghibli, then do the open AI should be accountable for the kind of the activities. How about that?
I certainly can't speak for what OpenAI should or should not be held accountable for. But I think maybe I would take a leaf from Professor UENO's book and to say that if the remedies don't sit within copyright, that perhaps the remedies actually sit within other aspects of law. And the issue is less about whether or not this is an AI issue. If an artist by hand copies the style of another artist, and if was able to work particularly fast and was able to produce maybe 10 pieces of work in the same style, the facts of the matter or the case that comes before the courts would have to be decided still in that same way.
Okay, great. 혹시 최 과장님 뭐 코멘트 하실 게 있으십니까? 아니면 다음 질문 넘어갈까요?
Mr. Choi, do you have any other? Yes, Ms. Choi, do you have comments? No? Okay, we'll move on.
Subscribe to the Gavin Fu from Singapore. 다른 국가들은 AI 산출
Other countries recognize the copyrightability for AI outputs, at least parts where there is human contribution. But does Singapore just wholly reject copyrightability of AI outputs without such consideration?
No. So what I was talking about is really, as I mentioned, AI-generated content, minimal or no human intervention. In those cases, if it's AI-generated authorial works, there's no copyright protection. But we actually welcome the concept of using AI to enhance human creativity. So it's a different situation where you're using AI as a tool and you can ultimately trace the work to a human author. And in those sort of cases, there is no impediment in the law to granting copyright protection if you can identify the human author. Yeah.
Actually, you focused upon the human author, and the kind of involvement of human author is the essential factor in deciding whether the kind of the AI output will be subject to the copyright protectable the work or not. So, 최 과장님 어떻습니까? 우리는 이 부분에 대해서.
Ms. Choi, what is Korea's take on this? I shared in my presentation, but when it comes to, we will be publishing a guideline on using AI-generated works, and as Mr. Fu just said, the contribution of human authors for AI outputs to those, it does have copyrightability. That was the conclusion of our working group and will be included in the guidelines. So on June 20th, we will address the public in a briefing session, and we will be receiving more feedback and then come to a strict conclusion and proceed. So as the moderator, if I may ask you a follow-up question, so human contribution is a factor, but it could be to a different extent. So is there any part of the guideline that you can disclose here? How much of an involvement are we talking about? Well, of course, that is a very significant and tricky question. To that, we will have to reference previous court cases, but the actual decision is to be made by court. So in our guideline, we will be introducing cases from other countries and many voices of the industries along with cases. So if these if these conditions are met, then we will deem that there has been human contribution. But this is just a guideline, and the specific determination will be made by the court on a case-by-case basis. So I don't have a clear-cut answer for that.
So as you know well, the MCST in Korea for the first time came up with a guideline regarding Gen AI. And so a lot of the jurisdictions are also coming up with guidelines that quote from the Korean guideline. So I think the Korean guideline is quite significant in that sense. I'd like to ask Mr. Han.
인간의 관여가 프롬프트를 입력하는
Then typing in prompts. Well, is that enough contribution for copyrightability? I think this is a discussion taking place in the academia. What is your take on that? The formula is simple, but how well is the prompt given? So is it in third person, in a very literal sentence, giving it a clear setup? Giving the AI such prompt could lead to a specific output. Similar debate took place surrounding an artwork. I can't remember the name of the artist, but it's a very Andy Warhol, I think. It was a very famous artist, and contribution to the output is somewhere between 5 to 10% is what the artist said. I plan it out and I give it the opportunity, but the one who actually puts in the manual labor and does the physical painting is someone else, not me. That's what the artist said. And the famous singer Cho Yong-pil in Korea is a similar case. And for the song called Hwatu, and copyright was recognized. So when we're talking about the extent of human contribution necessary, it has to go beyond just a vague idea that AI is doing all the work, but we have to look at specific previous cases to come to a clearer answer.
What would be human involvement to be applicable? To apply the current copyright law to protect that kind of work generated or assisted by the AI. What would be the opinion?
Yeah, look, I was having this discussion in a Southeast Asian country recently, and where they've got a registry, and they were saying that they want to reform their sort of registration rules and require people to declare how much AI was in the content to get copyright protection. And sort of we said, in 3 to 5 years, AI is going to be everywhere. I mean, there's AI in everyone's phones. You can buy AI-powered chairs. There's just AI is going to be everywhere, whether it's actually there or just marketed as being there. And so you won't be able to say how much is AI and how much is not. So maybe that sort of percentage approach doesn't particularly work. And I think what's indicative here in the copyright sense is, looking at Hong Kong, they have the computer-generated works protection, which is a shorter term of protection. I think it's 25 years, or maybe 50. And what they say is if it's an AI-generated work, where it's clear that the AI has generated the work, then it will fit into that computer-generated works protection. But if it's AI-assisted, and they don't really define what that is, then it will fit into normal copyright and have the normal term of protection. I think there's various legal theories here, but I think a good rule of thumb is how much control does the person have over the output, and that's a relevant sort of consideration. Yeah.
You mean actually the control of the control of the work will be the one of the factors that should be considered in deciding whether that kind of AI-assisted work is to be applicable to the current the copyright protection system. Okay, I think now is the time to move to the next question. The question number 5 also to the Professor UENO. You are so popular today. so many people wanted to hear your opinion regarding the kind of issues for today. The question is,
so AI is going to be a part of our everyday life, and there's going to be some clash with copyright acts of the many jurisdictions. So the core of the Copyright Act is that there is going to be copyright protection given to creations that express human ideas and feelings. But then the copyrightability of AI output, is it going to change how we determine that kind of copyrightability? And is there that kind of change in Japan? And also, can you maybe introduce how Japan is responding to changes in other jurisdictions regarding the copyrightability of AI output?
Thank you very much for your question about copyrightability or legal protection of AI-generated work. I didn't mention the part of the guideline on the copyrightability of AI-generated work, but the guideline deals with this issue. And actually, there was a long discussion about the legal protection or copyrightability of computer-generated work, even immediately after the Japanese Copyright Act was introduced, or the current Japanese Copyright Act was introduced in 1970. So there was a long discussion on this topic. But the key is the same. Here is whether such kind of AI-generated work has human creative contribution. So, and according to the guidelines, so it depends on whether AI-generated work or AI-assisted work has human creative contribution. But the most difficult problem is, as you said, prompt-based image. So the guideline showed the 3 factors to take into account to regarding the copyrightability of AI-generated work or prompt-based image. The first is amount of instruction, the amount of prompts. So, and the second is number of attempts. So if you attempt many times, the output would be copyrightable. Yeah. And third is selection from the many outputs. If you select one of them, so it will be affirmed the copyrightability. But just factors, the 3 factors will be taken into account. And it is still unclear And in Japan, there is no court cases. So, and there are many court cases in China and the US, and it seems there are differences between US and China. It seems in US, according to the guideline of the US Copyright Office, the threshold seems a little higher than in China, and sufficiently amount of content law is needed to affirm the copyrightability of AI-generated content. And in Japan, there's no court case and no majority view, and so on. As you know, the litigation is not preferred, not popular in Japan. So, but regarding the legislation for introducing a new right for AI-generated content or computer-generated work, there has been also long discussion in Japan whether to introduce a new regime to protect AI-generated work which is not protected by copyright. But the Japanese government decided not to introduce a new right for protecting AI-generated work or computer-generated work. But in academic theory, interestingly, there are several opinions to support the introduction of new right to protect and purely AI-generated work. It is also controversial, but I'm not supporting this idea personally, but it is also an interesting topic.
As you mentioned, in the copyright world, there's some scholars argue that actually the kind of sui generis approach has to be made to protect AI-assisted work, because actually the copyright law today actually they not give the full protection to this kind of AI-assisted the work. So that's an interesting topic you raised. And actually on Saturday I met the Chinese the lawyer. Actually he mentioned some kind of the Chinese cases as you mentioned. Actually it's very interesting to me. And how about the Singapore? Actually, the question they include some kind of the points on the kind of movement other than Japan. How about any kind of movement regarding the AI-assisted work in Singapore?
Yeah, so I mean, just now I've drawn a distinction between something that is AI-generated versus something that is AI-assisted. Right, and I said with AI-generated works, let's use the easy example of just how you have a simple prompt and the LLM spits something out. But what happens when you have many prompts, right? Very detailed prompts. Does it fall within the situation of AI-assisted works? I think something that we've considered and are still considering is, I think this is to some extent dependent on the development of the technology, because from our understanding of the current technology, even with many prompts, the problem or sometimes the obstacle is still with the issue of control, as we talked about. Because if you read, for example, the US Copyright Office's report, they likened the use of LLMs now to rolling a dice. So even though you have many, many prompts, in the end, there's still quite a lot of randomness. It is the AI that determines the eventual expression. And in that sort of situation, then it becomes a little bit harder to argue for copyright subsistence and to say that truly a human is in control and the AI is merely being used as a tool.
Okay. And actually, the Ueno Sensei mentioned something about the U.S. development, right? Actually, in case of the United States and the Andy Warhol case, the U.S. Supreme Court did not actually allow the application of the fair use to the specific case. And then what's more, actually, the U.S. CEO actually, in the case of the Dawn of Sharia, actually selection of the kind of the elements of AI generated works could be applicable to the copyrightable works in terms of copyright eligibility. Do you share something about the US development in the AI assisted or AI generated work, Ms. Lee?
I'm going to take a cop-out answer here and admit that I'm not a copyright expert when it comes to US law. I might want to throw this question over to James and see if he's got a perspective.
Okay.
I'm also not a US copyright lawyer, so, but I think, if we take a step back and, we're talking about whether, AI-generated work should be protected by copyright, it's like, well, under sort of a theory of why we have copyright is it's an incentive to create new works. And we give copyright to humans to kind of reward and provide an incentive for that. Because otherwise, they wouldn't create new works, right? I don't see that as a problem for AI. I think there's no problem of there's no AI slop on the internet. Like, there's quite a lot. And so I just don't see how that fits in. I mean, my boot's not protected by copyright. Should it be protected by copyright? I'm not sure. I think it's like, what are you trying to achieve by protecting these things?
Great answer. Actually, the only one who didn't make any answer to this question is Mr. Ham. So, do you have any opinion or ideas to this question, or skip, or
skip, please?
Okay. Let's move to the final question. Question number 6. Actually, it's a very general question. The question is 저작권과 생성형의
Can copyright and generative AI coexist? If so, what change and efforts should we make to that end?
Has to be, answered by every participant, every discussant here today, because it's a kind of very philosophical question. Actually, the question touched upon a kind of very foundation of the copyright law. Actually, we all knew that copyright law is the law to enhance the creativity of the human beings, and that the human beings has to be centered on the copyright work and copyright law. It's actually very agreeable foundation for all of us. But still, actually, this kind of the generative AI development will affect a lot of the impact to the copyright law. So, can we coexist with the generative AI? I think the answer should be starting from Ueno Sensei. Is it okay? Yes. Or if we want to, actually, you will be the last person to answer.
No. Yes, as I mentioned before in my presentation, it is important to coexist with our AI technology and copyright law system. And it will be important to conclude a contract, as I said, between AI developer and copyright holders, so that it is possible. So as I said before, there is a TDM exception in Japan. So AI developer don't need to have to obtain authorization from copyright holder to conduct TDM activity. But AI developer in Japan would like to conclude a contract with copyright holders because it would be much easier to gain the digital data, bulk of data, to train an AI. So it is also possible without contract, without authorization, to buy, for example, the journal, medical journal, and the back numbers, and scan by hand to copy the copyrighted work to conduct TDM activities, but it costs a lot. So the AI developer would like to conclude a contract with copyright holder, such as journal publishers, to gain our bulk data of digital journal collection. So I'd like to emphasize that it is possible and very valuable, even for AI developer, and even if the AI activity is allowed under the TDM exception. So contract is an agreement. And the license is based on copyright, exclusive right. So in Japan, our contract is not necessarily license, but it is irrelevant. So contract is important. So it is my opinion. And I believe they, namely AI developers and the copyright holder, will reach an agreement in the near future. Currently, the price is too high, too low, so that's are a little so competing, but they will reach an agreement in the future, I think. And that is what I call win-win relationship. And so in the future, so very soon, so everyone will reach an agreement. So. Okay, that's my question.
Okay, thank you, Ueno Sensei. And next will be the Mr. Pu. Could the generative AI and we, the human being, can coexist in the world of copyright?
Yeah, I think it must coexist. I think technological disruption is constant to copyright. You look at the history of it, you've considered copyright in the context of photography, photocopiers, the internet, and so on. So we've always had the ability to respond to the technological changes through the copyright regime. In some cases, you may not need changes. When you talk about output infringement by generative AI, actually, I think based on Singapore law, the existing principles and remedies are sufficient for providing sufficient clarity and guidance and giving rights owners the ability to sue for infringement. If you look at how some of these developments worldwide, some of the discussions, some of the areas that I think are being looked into now would be what we discussed today, right? Transparency obligations when it comes to data sources. And perhaps another area that will become more important is also what we discussed. How do you use generative AI as a tool? And in such cases where you're using generative AI and you're using multiple prompts, is there a possibility of granting copyright infringement? And where do you then draw the line between something that is not copyright protected and something where you're using generative AI as a tool? And sometimes these changes or clarity, I guess, need not necessarily come from the government. The courts also play a very important role in that. And sometimes I think we also need to let some of these developments take place organically so that we don't inadvertently hinder innovation. Thank you.
Yeah, thank you, Mr. Pu. Actually, there are many discussions actually today. Actually, they put an emphasis upon the law of the court of the world. Actually, but still, actually, the administrative body also actually has to play an important role in, providing some guidelines to the market. So, 최 과장님 어떠십니까? 공존 가능하세요?
So what do you think? Is it coexisting possible? So as Mr. Gavin Fu had said, the technological development had also led to the evolution of the copyright regime. So I also believe that with the new technology, the copyright regime is going to evolve in the future as well. But the most important thing, I think, is that AI is continuing to evolve and develop. And for that to happen, creativity and human creativity creative works are necessarily to boost AI further, which means that we have to incentivize the creativity of humans. So despite the development of new technology, we nonetheless have to be able to continue to boost human creativity through different policies and different systems and regimes. And only when we have that human contribution can AI, industry, and the national economy all develop, and that in turn will also provide better tools for the creators to be able to use. And I think that's going to contribute to the coexistence.
You know, the philosopher, German philosopher, Walter Benjamin. So actually, you mentioned Benjamin. So actually, I love to. So what would be the closing remark whether we could exist with the generative AI or not?
I think it's a bit of a mistake to frame it in opposition to each other. I mean, like other speakers have said, you know, there's technology and I pointed out hopefully in my remarks that technology and technological disruption is a feature of copyright law, and how the response is and copyright's been doing this for over 150 years. So there's nothing new here, and to that end, I think the current copyright settings in most countries in the world don't feature interventions into the market like text and data mining exceptions. So they offer kind of an incentive for players to engage in risk. And if you look at it in that regard, the market's operating as it should. There are players that are engaging in risk, and they're getting sued for that appetite for risk. And there's players that aren't. And where this all ends up with the court cases in the US will, I think, have a far greater influence on the development of AI globally than anything else that happens. But I think the market should be left to sort this all out, and government should try and stay out of it as much as possible.
Okay, thank you. Ms. Lee?
Well, I'm going to use my optimist answer and say yes, it's a resounding yes. Short answer, resounding yes. I actually echo James's point. I think this is the wrong question. I think the question really should be for each country to ask themselves, what is our value proposition when it comes to AI development or when it comes to the creative industry, and what is the direction in which we want to chart in order to remain globally competitive? And I say this with a lens of looking across Asia Pacific. When I look at Japan, for instance, it is not just their TDM exception which is considered permissive. It's their overall approach towards AI. You see that in the AI Basic Law, which they have just passed. And when we look again at Singapore, when we talk about their copyright exception, or the CDA exception, it doesn't exist in a vacuum. It exists together with an AI model governance framework, which the IMDA has put out, which is voluntary, guidelines focused. So it seems to me that each country is kind of taking that approach of asking themselves, what do they want to cultivate in their country? Do they want to grow the AI ecosystem? How do they want to do that? And then they should come up with policies and interventions, including, of which copyright is just one part, in order to kind of help that country to achieve the outcomes that they want when it comes to AI.
Okay, great. To summarize, actually, the clarity, and clarity for the developers. Okay, finally. You are the last person to answer this. Please.
예, 최 교수님 사회고시 나이 많이 쓰셨습니다.
You really did a great job as a moderator first, Professor Choi, and I have two points to make. So every time a new media emerges, the law that continuously changes accordingly was the Copyright Act. In the 1890s, the photography technology was developed, and there was debate over whether it is copyrightable, and it was recognized. And at the end of 1970s, there was also the debate on a new technology, and the copyrightability was also recognized. And before AI, if we look back on the whole boom of metaverse, what takes place? in that virtual world can be tracked. As for example, our credit card history can be tracked, and wherever we go, we're being filmed by CCTV. So I think we will come to a point where all of the sources used by AI will be able to be tracked and listed, like the NFT technology. So if listing of all sources become possible, then when a revenue is incurred, then we need a system to distribute that appropriately. I think the policies from the KCC and the relevant Copyright Bureau is at a time where they need to start those discussions. And if we continuously deploy and use Gen AI, what copyrighted works were used and to what extent will be diluted and blurred over time. So dilution will take place. When we reach that point, then Gen AI may be further distanced from the concept of copyright, and that is probably something to take note when making policies.
Copyright is a reservoir of the our works, and then actually it's a kind of mechanism to redistribute the revenues generated by the works. So it's, I think, a wonderful expression to describe the essence of the copyrights. I think time is up. Let's wrap it up for today. It's my honor to be with the wonderful discussion here today, and I wish you guys actually enjoy the discussion of us. Thank you. Thank you for all of us, all of you.
네, 긴 시간 토론 및 질의.
Thank you, a moderator and all panelists, for being with us and joining us for this discussion for such a long time, and you may now return to your seats. Today, through the panel discussion, we explored very challenging but imperative questions surrounding today's topic, and AI and copyright can coexist was the bright note that the panel discussion ended on. So I'm very glad, and we now concluded the entire program prepared for today. So all speakers who prepare preparations and all participants joining us on site and online, thank you very much. And this brings us to the closing of the Seoul Copyright Forum 2025, and I hope to meet you all back in the same forum next year. And it was Ivanova signing off as your host for today. Thank you.